All right, good morning, everyone.
Good morning, Your Honor.
My name is John Hurley. I'm your judge this morning. We're in first appearance court. Today's the day the court determines whether or not there's probable cause for your arrest. We're not here for a trial. We are not here to determine whether you're guilty or not guilty. That is not for today. You do not need to share with us any defenses, any excuses, any explanations regarding your arrest. Those things are better saved for your attorney in a private meeting. Understand you have the constitutional right to remain silent, but if you give up that right, whatever you say can and will be used against you. Also, if you have a private attorney, when you call forward, let me know who that is. We'll contact your attorney and let them know that you're in court today. Now, which attorney was in here first? Okay, go ahead, sir.
But, Your Honor, if you could, Katie Bogenschutz is going to be coming down. She'll be here momentarily on this case.
Can you stand by just for a minute? Until
Absolutely,
Ms.
Your Honor.
Bogenschutz gets here?
Absolutely. It's on page 13, by the way, Your Honor.
Which case is it?
Pelayo Cerulia, Cerulia, on page 13, about midway, Judge.
Sure.
Shane Davis.
Mr. Butler?
Good morning, Your Honor.
Good morning, sir. How you doing?
I'm doing fine. I have Shane Davis.
Let's see Shane Davis, please.
I represent him on another matter that was previously pending, and your office gave me a call this morning.
Right, okay.
I noticed that bond has already been set.
Well, let me get him up here. Where's Mr. Shane Davis? He's the very last person on today's docket. Shane Davis.
Judge, we got to track them down. They didn't have a page 27 over here.
Okay. Let me look.
Yeah, you take that.
Thanks. I didn't hear that. Is he on his way?
They don't,
Judge, they're looking it up, find out where he is.
Okay. Got it. Okay. Can you have a seat for me, Mr. President?
Hey, Judge,
Yes, sir.
can I get about 5 minutes? I was right in the middle of my speech when you came on.
Yeah, what about if I called up the MOs? Can I call up the MOs, or do you need quiet time?
Nope, that's fine.
Okay. You ready to go?
As you wish.
Okay. What about
Jennifer,
Francis? No, I'm sorry, Jennifer Johnson.
looks like she's in North Broward, Your Honor.
Jennifer Johnson.
She's on page 3 of the docket.
North Broward. On the X.
Hi, good morning, Ms. Johnson. Count one is a state charge for petty theft. That's a failure to appear in court. Count two is a municipal ordinance charge, and count two is an open container of alcohol. Ma'am, are you currently employed?
No, sir.
Excuse me?
No, sir.
Okay, do you have money in the bank?
No, sir.
Okay, can you afford to hire your own attorney?
No, sir.
Would you like me to give you a free attorney, a special public defender today to represent you
Sure.
on count two?
Sure.
Okay, so I'm going to appoint Mr. McLawrence on count two. Ma'am, are you on probation right now for anything?
No, sir. No.
You know, if she wants to resolve count two, we could just withhold adjudication on count two for a plea of no contest, and then she'll have to deal with count one.
Okay.
All right?
Yes.
How do you feel about that?
I feel fine with that, Judge.
Ma'am, if you want to plead no contest to count two will be resolved today.
Okay.
And then it's over with, but then you'll still have count one, which is a theft charge, and you'll have to resolve that later on. That bond's $500, all right?
When can we resolve that?
Well, I'll let you go to your trial judge and resolve it. There may be a restitution issue there, and I'd like you to go see your trial
Okay.
judge on that, all right? Would you like to resolve count two?
Yes, I would.
Okay, ma'am, how do you plead to count two?
No contest.
Do you understand that you're not going to have a trial, you're not going to have your day in court, it's wrapped up right now? You
Yes,
understand
sir.
that? Okay, I'll accept your plea, withheld adjudication. Good luck, ma'am, thank you.
Thank you, Judge.
Thank you.
Okay.
Augusta and
Now, do we have anyone else? Ma'am, are you here on a case? Excuse me? Okay, great. All right. Sir, back there, can I help you?
I'm in
And
here
I'll
for
be
a
here.
patient
Whatever you
named Andrea
can do, I really
Jameson.
appreciate it.
Andrea Jamison?
Thank
Yeah,
you.
she never got a court letter to go to court.
Okay, we'll call her up. Andrea Jamison?
Sir.
Stand right up there. There you go. Andrea Jamison? I don't see it.
I'll check. If it's a felony capias, they wouldn't have brought
Yeah,
her.
are you sure it's supposed to be in here this morning? Sir?
I don't know. I don't know if I'm in the right one.
Okay, well, we'll look into it. We'll see if how we are here.
All right.
It's not on our docket. Hold on, sir. Just stand by it. Let's try to figure out where this gentleman
And
is.
no, I don't think she was arrested yesterday morning, but it's a felony capias, so he might have called and they said, oh yeah, go to room
Do
235.
we know who the judge is? Send him over there.
Well, I'm just telling you, I'll check Odyssey, but I doubt, it was arrest on the capias yesterday. Usually you don't get court dates that quickly, but. Yeah, she doesn't have a court date. It's in front of Judge Robinson. Probably the best thing you could do at this point would be go to the she's represented by the public defender and go there. And
Could she be on this morning's docket?
no, I'm checking Odyssey. The capias was just served yesterday. They don't give court
Does
dates
she
like
have a
that.
public defender representing her?
I don't know, cause Bill's woman, no, he not got so wait for her to go to court and stuff like that.
You know what? Let me do this. All right, how we doing over there, Mr. Miller?
Judge, we're done here. I do appreciate the extra minutes.
Okay, so we'll get to that one. Now,
You want Cerulia?
we're waiting on Shane Davis. Is somebody looking for Shane Davis?
He's on his way, Judge.
Okay. Now, okay, may I see Glenn Thomas, please? Hey,
Main
sir.
jail.
Good morning. You got a domestic battery, sir. The court finds probable cause and state. Are there any priors on Mr. Glenn Thomas?
One moment, Your Honor.
Was there any contact with the alleged victim, ma'am?
No, on this case, Your Honor.
Okay. Mr. Thomas, how long have you lived down here in South Florida, sir?
Judge, he's been here for 63 years. He does have strong family ties, including his brother, his sister, his cousins, his entire family. He's been working for Florida Heat Pump for the past 20 years. He's a registered voter, has a place to stay that's separate from the alleged victim while this is pending. He'll be asking his family to bond him out, Judge. It's his first time in ever being arrested. Ask the court to consider pretrial release on him.
Okay.
We made a copy.
We had 1971, a firearm.
No contact, correct? So I'm gonna set your bond at $1,000 based on the level of violence, facts of the case. I'm gonna order so you have no contact with Letitia Ferguson. Don't call her, don't text her, don't email her, stay 500 feet from her at all times. That is where she lives, works, goes to school, anywhere in between. You're not allowed to possess any guns, any firearms, any weapons while you're on release. Thank you.
Courtroom.
Is he Charles Smith?
North Broward Jail.
Hey, how's it going?
Charles Smith, aggravated battery, domestic battery, resisting arrest without violence, and possession of cannabis. Court finds probable cause. Do we have any criminal record on Mr. Charles Smith?
2007, resisting without violence. 2001, battery. 2001, possession of cocaine. 2003, possession of cocaine.
I guess these two, this thing was set up with the three of them.
Okay, Mr.
I did speak with him.
Robbery in 1990.
Got it.
He went to prison. He had a 1989 possession of cocaine, also went to prison on that charge. Cocaine possession in 88. 86, also possession of cocaine. He does have priors. Does the court want me to?
Yeah, that's fine.
Judge, I did speak with him. He's a resident of South Florida for all his life. He currently lives in Hollywood, resides in an apartment where he pays $210 a month. He only has $180 in his bank account. All his family is here. His mother lives in North Lauderdale. He gets $733 a month in disability. I don't think anybody knows he's in custody, and I don't know he would rely on his mom to bond him out, but she gets disability. She doesn't have much to bond him out.
Ma'am, did you have contact with the alleged victim?
No, Your Honor.
Okay, sir, based on the facts of the case, you have a prior battery, prior armed robbery, some drug charges. Sir, based on the level of violence, court's gonna set your bond on count 1 at $5,000, count 2, $1,500, and I'm going to release you ROR on count 3 and 4. And I'm gonna order, sir, you're not allowed to have any contact directly or indirectly with Abby Wesby. Don't have any contact with her. Don't call her, don't text her, don't email her. Stay 500 feet from her at all times. That is where she lives, works, goes to school, anywhere in between. You're not allowed to possess guns or weapons any firearms, ammunition while you're on release. Thank you.
Judge, I'm asking for a mental health screen.
Sure. I'll order a mental health screen on that, gentleman.
Thank
Sir,
you.
Orville Massop. Orville Massop.
Yes, main jail, we have an argument.
Okay, sir, aggravated battery with a deadly weapon, count 2 burglary with an assault or battery, 3 criminal mischief, 4 criminal mischief. Go ahead, what's your argument, sir?
That's,
Is that it? Count 3 and 4, no value?
No, Judge, it's more than that.
Okay.
Okay, there is no, the evidence alleged to link them to count 3 and 4 is that they said they found some stuff in the car, but there's no witnesses that would attest that he had anything to do with the damage to their car. I don't know that you can make a probable cause determination based on things that were found inside the car. It just, I mean, they didn't even find spray paint. They can't link a color to him. I'm looking at his hands. There's no paint on his hands to show that he would have had spray paint on him. I just don't understand how they can link him to the damage.
I understand. I got your point. Go ahead, state.
well, just on 3 and 4.
Well, I'm not done yet,
Mhm.
Judge.
Oh, okay.
As far as count 1, the PC says that he was the alleged victim was hit with an unknown object.
Right.
So how can we determine that it's a deadly weapon if we don't even know what the object is? Now, there is an allegation that he attempted to hit him with a bottle, but that's an assault, not a battery. And so we have no probable cause for an aggravated battery with a deadly weapon in count 1. And on count 2, Judge, you'll notice the alleged victim listed as C. Massop, that's this man's wife for 27 years. Somehow that has been left out of the probable cause affidavit. And what he's telling me, this is his house. He's been living there since November. It's not on his driver's license. He hasn't changed his driver's license yet, but this is his house. And I don't understand how we can avoid the fact that this man is married to this woman and it's not in the probable cause affidavit. Something's wrong here, Judge, and I'm arguing there's no probable cause for a burglary. At the best, you have a battery and perhaps an assault with a deadly weapon, and no evidence of a criminal mischief. And I'm asking the court to find probable cause and set the bonds accordingly.
The court will find probable cause to the aggravated battery. The court's not sure that if it hinges on whether or not the alleged victim can identify the weapon. You could imagine a situation where someone's in a dark alley and they get hit over the head with a hard object. They didn't see the object, but they know they got hit over the head with it. Not sure that you can disregard that it was a deadly weapon. Now, that being said, count 2, burglary with a battery. State, are you seeking to hold him without bond?
Yes, I am, Your Honor.
Okay, well, count 2, it's very clear here in the court's opinion. It says that he forced his way into a residence. It says right here, the defendant also attempted to strike the victim with a glass bottle. It says, according to the victim, the defendant does not reside at the residence and has never resided at the residence in the past. And she did not invite the defendant to the residence. She did not authorize him to enter the residence at the time of the incident. The victim stated the defendant forced his way into the residence by physically forcing open the door with his body and then entering the residence to attack the victim with an object. Now, the court may tend to agree that 3 and 4 are not that strong. I mean, circumstantially, he did have some spray paint, I believe, and I would agree that nobody saw him do it, and they have an argument there. But as far as count 2 goes, do you have any issue why it's not proof evident, presumption great today, Mr. Miller?
Again, I'm not arguing proof evidence presumption grade. I'm arguing against probable cause. And I would just argue, Judge, I understand the court's use of hypotheticals to explain situations, but in this situation, they're alleged to, the allegation is that he forced his way into the apartment, okay, his own apartment. There's no allegation that there was evidence of a forced entry. Okay, this man has a key. He opened the door with the key, surprises his wife with her boyfriend coming home early from a trip. He works as a truck driver, comes back from Tennessee on a trip, surprises his wife, and gets surprised by her boyfriend. Judge, there's not, again, what's left out of this probable cause affidavit, the fact that he's married to this woman for 27 years, is very telling in the lack of probable cause, and I would argue proof evident presumption grade as well.
Yes, sir. The issue the court has is you are going out of the four corners of the document by saying he had a key to the residence, that he's a truck driver, and he just came home to surprise his wife. Things of that's outside of, there's no testimony to that. There's no evidence of that. That's what you're telling me, and I know that's what your clients told you. However, that's not in the record. I mean, we don't have.
I understand, Judge, but there's also no evidence on the record of a sign of a forced entry, which is contrary to what it says on the PC. So that they say he forced it in, but there's no evidence of a forced entry. That would naturally be included in the PC if there was, in fact, a forced entry.
Yes, sir. The court's going to find proof evident presumption greatest to count 2. Count 3 and 4, no probable cause, ROR. Sir, do you want to make any argument about bond on count 1?
We'll stand mute, Judge. Thank you.
Okay, court's going to set
All right,
the
get
bond
that list together.
on count 1 at $10,000. Count 2 is going to be held without bond, no bond hold.
Your
And
Honor.
then, go ahead.
The defendant is currently out of custody on a pending case, grand theft between $20,000 and $100,000, and false support of the commission of a crime.
Case number?
152921 CF10A. Here's what.
Court's going to revoke the bond on 152921 CF10. That bond's revoked.
Yeah.
Defendant's held without bond.
Okay, it's around
Thank you.
235.
And also, the court's going
If
to
you
order
go
has
in
no
the main-
contact
if you go in the
directly
main lobby of the
Maureen
courthouse,
Massup and
There's
Ladue Law.
an escalator there.
Okay.
If you take that escalator to the second floor, my courtroom's right there.
Brian
235.
Calloway.
Can I get your
Pretty
cell?
far.
Judge, we found Mr. Davis when you're ready.
Okay, Brian Calloway.
He's over at the North Broward jail. I did speak with him whenever the court's ready.
Mr. Calloway, you are charged with aggravated assault with a deadly weapon and resisting arrest without violence. Court finds probable cause. Mr. Russell, do you have something you'd like to say today?
Judge, I'll just wait on the state with the priors, and then I'll go into his ties.
Does he have his criminal record?
One moment, Your Honor.
Yes, Your Honor. 2015 had a domestic violence battery by strangulation. 2012 domestic violence battery that was dropped.
Got it.
And out of Alabama, looks like he had a domestic violence harassment. 99.
Judge, he's a resident of Fort Lauderdale, Florida for 11 years. He's currently gainfully employed. He's a service guy at a tire shop. As of now, he has no money in the bank. He does have a fractured hand, and part of the PC, he was bitten by a pit bull, so I'm going to ask for a medical screen. He's going to get paid on Friday. He has no way to access his money, and Mr. Calloway wanted me to ask the court to release him pre-trial release.
Court's look, was there any contact with the alleged victim, ma'am?
No, Your Honor.
Okay, defendant and victim been married for about 8 years. She had 2 children. Allegedly picked up a hammer and lunged at the alleged victim with the hammer. Said, "I'm going to beat you with a hammer." Allegedly made threats to kill the alleged victim and the children. Allegedly was found pouring gasoline by the police when they arrived around the house. They thought he was about to light the house on fire. And there were children in the home. And did you say he has family down there, sir?
I don't believe he has any other family down here.
No? Okay. Sir, the court is concerned about the safety of not only the alleged adult victim, Ms. LaRonda Calloway. The court's also concerned about the safety of the children. It's alleged you poured gasoline in or around the house. When the police got there, they allegedly saw you drop a gas can and run. They smelled the gasoline. You allegedly made threats to kill, and based on that, sir, the court's going to set your bond on count 1. And the court also notes you have a history of domestic violence out of Alabama and out of the state of Florida. 2 arrests out of Florida and 1 arrest out of Alabama. So it's going to set your bond today at $150,000 on count 1. Count 2, that court is going to set that bond at $1,000. And the court's going to total bond is $151,000. You'll have pretrial release with the GPS monitor. The court will waive the cost of the monitor. That'll be a level 1 lockdown. You'll have house arrest. Court set your bond based on this court's great concern that the safety of the family, not only Ms. Calloway but the children. As the court said, you allegedly were attempted to burn the house down with them in it. And the court will order no contact with Veronica Calloway, directly or indirectly, no contact with the children, 15, 12, 7, and 4. You must stay 500 feet from all of them. Where they live, work, go to school. Anywhere in between, you're not allowed to possess guns, firearms, or ammunition if you make bond.
Judge, will the court at least do level 2? He is employed at a tire shop and allow him to work if he's able to post
Under
bond.
these circumstances, the court's going to leave it at level 1. If he wants to go in front of his trial judge and ask for a reduction or a modification, he can do that. All right? Now,
Okay.
you want to go now, Mr. Lon Butler?
Yes, Shane Davis.
Yeah,
See Shane Davis.
I just, yeah. I saw
Mr. Shane Davis, I think I told you yesterday, I'll tell you again. You have the
Okay,
right to
yeah,
remain
so-
silent, but if you give up that right today, whatever you say
Don't worry about it.
can and will be used against you. Everything's being recorded. Do you understand that? Turn on that mic for us. Do you understand? Okay, good.
Yes.
So you're being represented today by a very fine attorney, Mr. Lon Butler. You don't need to make any comments. Statements. Let him speak on your behalf. All right, sir?
Yes, sir.
Hey, Mr. Butler, good morning.
Morning, Your Honor.
Sir, have you had a chance to read the affidavit? We have an affidavit here. You had a chance?
Yeah, I've had a chance to read it.
The court, do you have any issue about probable cause, sir?
Well, I think prior to issuing the warrant in court, the judge made a determination of probable cause. I would object because I don't feel that there are sufficient facts in there to indicate probable cause. It basically indicates that there was a gold car similar to the one that he had, and there was a supposed identification by the alleged victim, but there are no specific points of identification that were mentioned by the alleged victim, other than the fact that it was a gold car, and they're trying to relate that to another offense for which he was previously charged. But I see nothing that specifically identifies Mr. Davis as being the driver of the gold car.
Your Honor.
It says right here that the female LB, that is Lima Bravo, on January 15, 2016, came into the Plantation Police Department, shown a photo lineup by an independent detective. LB identified Shane Denarius Davis as the person who exposed himself.
Well, Your Honor, it's a lot more than just that. She gave a physical description of his hairstyle. She mentioned he appeared to be wearing what appeared to be a Dollar Tree uniform. They go to a Dollar Tree store that is right in the proximity where this occurred. It just so happens Mr. Davis is an employee at that Dollar Tree store. He was working the day and left at approximately the time where it would put him in the vicinity of where this allegedly occurred. It's a lot more than just an in-person identification and the car.
Okay. Well, court's going to find probable cause over there.
You have an attorney. You need to talk to him.
Let me ask, does he have a criminal record state?
Your Honor, and I provided the court with a copy of the report. He is currently out, Your Honor, on bond for lewd and lascivious exhibition.
Okay, when was the date of that incident? When did he bond?
Your Honor, it was May 13th, 2015 is when it occurred, allegedly. One moment. I mean, he was obviously out on bond before this because this allegedly occurred in, I believe, December, 16th day of December, but for the record, I'll get the exact 15-66-82 CF10A. Your Honor, and as you can see from the probable cause affidavit provided, Your Honor, it is similar circumstances as the allegations in this case. He posted bond May 26th of last year. Your Honor, I would also note, as you see on count 3, there's a hold out of Hillsborough County. He was picked up in Hillsborough County for possession of marijuana. Your Honor, it's obviously up to the court whether you decide to sua sponte or revoke bond or not. The bonds on this matter, I'm going to be asking for that the $15,000 bonds on each count be disregarded. One, I believe the court has jurisdiction regardless to either lower or raise bonds set an arrest warrant. But additionally, Your Honor, if, and with all due respect to Judge Bailey, if he had followed the administrative order in place in the circuit right now, he would have put these bonds at no bond pending the first appearance, which would allow Your Honor to set the bond you deem to be appropriate. Frankly, there's no mention in the warrant affidavit, so I can't assume that Judge Bailey knew that he had a pending legal lascivious exhibition when putting the bonds on these warrants. Considering the strength of the case in both cases and the allegations, Your Honor, I'm going to be asking for $150,000 bond each count. Should he become eligible for release on this case, pre-trial release with a GPS monitor level 1.
Let me ask you this, does he have a criminal record though?
One moment, Your Honor. Patrice, do you still have minutes from yesterday?
What county?
While you look for that, Your Honor, Judge Bailey had an opportunity to review the PC affidavit, and based on the facts alleged in the PC affidavit, Judge Bailey sought that set a bond of $15,000 on each count. So there was a determination of probable cause, determination of bond amount, and you can't really speculate as to what Judge Bailey may or may not have knowledge of prior to setting the bond.
I understand. The issue, though, and the state brings it up, is there's a bit of a, on one hand, well, a couple of things. From what I understand, the case law, the court is familiar with regarding first appearance, if the judge finds probable cause on a case, that is something that can't be disturbed. However, release conditions, the defendant is entitled to, and it can cut both ways, a de novo review at first appearance for release conditions. So the opposite or the extreme example could be true. Let's say another judge gave him a $5 million bond by signing the arrest warrant, put $5 million. Well, even though the judge found probable cause, this court can still review the bond amount and the release conditions at first appearance. They could be too high, they could be too low, and each defendant has the entitlement to have an a la carte or a, that's my word, but a de novo review of bond and release conditions at first appearance. Sometimes it goes before the defendant, sometimes it can cut against the defendant. Go ahead. State yes.
Right after. Outside. Mr. Commander? Do you have an attorney? I can hire your own people to come. I remember that. I'm sorry?
Got it. Okay. Anything else, Dave, on this matter?
Your Honor, the only thing I would bring to the court's attention, I did have an opportunity to review the probable cause affidavit from Tampa. I would note, Your Honor, it appears that a gun was found in Mr. Thomas's possession, unloaded. He did mention that he had a weapons permit, concealed permit. It is currently suspended, Your Honor. That'll be a matter for Tampa law enforcement, state attorney's office in Tampa, determining whether he had notice or knew that it was suspended or not.
Okay, Mr. Butler, I'll let you give your final pitch here, but let me just say the court is very concerned. This defendant allegedly is approaching young women when they're walking home from school, 15 years old in one, and I'm not sure how old the young woman was on another one here. But allegedly, he's approaching young girls coming home from school in the afternoon and exposing himself. And it doesn't look like it's an isolated incident. And the court does note that he's out on bond right now for the same type of matter. Let's see here. Several checks were conducted. The defendant, in similar incident, was peeping through a window where a lady was taking a shower. So that's the other incident, but
That's I don't believe that's an incident for which he's been charged.
no, I understand that. I understand that, but the court is concerned. The court relies on his memory of attending a seminar.
Your Honor, I just want to be clear because I think that might be the other case. Because I can tell you, and I have a PC from the other. It involved a similar incident. A 15-year-old. It's alleged a 15-year-old juvenile approaching a woman from his car. Observed him masturbating. He was actually caught on video, Your Honor. But so I just.
Okay, well, the court's experience of being an attorney since '90, being a prosecutor, private attorney, judge. I've attended seminars where I've been taught that people who expose themselves to women like this is a precursor to bigger things. They're gonna perhaps the next step after this is abduction and things like that. That's what the court's learned over the years. And that gives the court great concern for the safety of the community, especially young women trying to get home from school, and this gentleman's allegedly confronting him. So I'll let you give a picture of your.
Your Honor, the purpose of bond is basically to assure the defendant's presence. There's been no indication that he never appeared for anything. It's my understanding, and I believe, as to the prior case that's already filed and pending, that I just received a current motion to revoke that bond. So if the court would see fit to allow the current bond to stay in place, I would submit that that's sufficient to assure that the defendant will appear on these particular charges. And the other court already has jurisdiction over the other matter and the pending matter as far as a revocation of bond.
We're just going to set the defendant's bond today.
Yeah, we got a couple of them back there.
Count 1 and 2 at 25,000.
Two of them back there.
Count 3
What's his name?
hold 2,000. They'll have pre-trial release, GPS monitor. They'll have it's going to have level 1. That'll be a house arrest. Court set his bond based on this concern. This is ongoing criminal activity. Activities consistent with the case he's allegedly out on. We're just going to revoke the bond he's out on, 15-6682 CF10. Will be held without bond. The court does note the defendant's criminal record. And the court's concerned
Yeah, well, I'm
with
going to be
safety.
resetting that for the afternoon.
All right?
All right, thank you.
For the afternoon.
Yes. If I can do any of the alleged victims in this matter.
No, he's jumping yesterday.
I did, Judge.
Now we just need to take about 2 minutes to read it.
All the way down.
What they tell me though?
You have an attorney? No, I'm holding it. All the way out. All the word.
Okay, may I see, Mr. Palaio Cerulia? Palaio Cerulia.
Judge, can I hand over a copy of an order issued by Judge Siegel on Monday?
Sure.
Oh, yes, Judge. We actually went to an Arthur hearing on this case, I believe January 20th and 21st. And Judge Siegel issued an order setting his bond on the one case where I had a non-bondable offense, which was 16-31, which is why that's the case number at the top.
Okay. Which count would that be on here? Do we know?
It is not one of the counts on here. We filed the cases as 4 separate cases. There are 4 separate victims we're proceeding on in this case. I have all the case numbers over here with my little box, but this one would be the 16. Excuse me. 1423, and the victim's initials are LR. There's 3 other case numbers. There's one 16900 CF10A that was already filed. Victim's initials are KD, and then 16901 CF10A. Victim's initials are CO. And then the top case, which is the 1631 that had a count of burglary with a battery, which was the reason for the Arthur hearing, is victim AS. So we filed them all separately because it's pretty much a classic Williams Rule identity case.
Let me just take a moment.
Sure, Judge.
Back on the record. Could you state your name, sir?
Yes, Your Honor. May it please the court. Good morning. My name is Robert Pellier, P-E-L-I-E-R.
P-E-L-I-E-R?
Yes, and I represent Mr. Cerulia.
Okay. Could you state your name for the record, ma'am?
Yes, Your Honor, sorry about that. My name is Kathleen Bogenschutz. I'm an assistant state attorney assigned to this case. I apologize, I'm a little bit sick.
No problem. Let me advise Mr. Cerulia, you have the right to remain silent today. You're not required or expected to make any comments or statements about your arrest, about any of these charges against you. But if you give up the right to remain silent, whatever you say can and will be used against you. Do you understand that, Mr. Cerulia?
Yes, Your Honor.
You're being represented by an attorney. You should allow him to speak on your behalf today. Now, we're here on count 16, throwing a deadly missile, 17, aggravated stalking, 18, 19, 20 are all criminal mischief. Those bonds are 25. I don't think we're going to argue about that, right?
They've already been posted, Judge.
Okay, so we're here to determine, number one, probable cause for 16 and 17 and any release conditions that are appropriate. So, Ms. Bogenschutz, I had a chance to read the submission you gave me. I didn't go through every one of the individual police reports, but I read the Pembroke Pines Police Department. It's kind of an overview of everything that allegedly happened, and it lists the alleged facts, and then reviewed the order on the Arthur hearing, which was signed and ordered by Judge Siegel. So is there anything you'd like to state today about this matter and why you think, what bonds you think are appropriate?
Judge, I obviously went forward on the Arthur hearing, hoping to hold him no bond. I believe him to be a danger to the community as a whole. There are multiple incidents over a period of 2 years, and I know Mr. Pellier is about ready to object when I mention his 2007 arrest in Miami, which was sealed He pled to a withhold for a battery, and it was sealed, but it was a very similar circumstance where he was walking around an apartment
But
complex.
this is wholly inappropriate, knowing full well.
Why is it inappropriate?
Because, Madam State Attorney understands that there's been no conviction in that case, and the matter's been sealed, and it absolutely has nothing to do with these particular cases.
Well, number one, there's two issues. The court believes that prior conduct after probable cause has been found is relevant, prior conduct, whether convicted or not. The second thing is the issue about sealing. That may be a better argument. I'm not aware, is it sealed? Are you not allowed to speak about it? Are we not allowed to discuss it?
Judge, I'm unaware. When we executed the search warrant on Mr. Cerulea's residence, wherein we found multiple hunting marbles that were consistent with the hunting marbles that were being shot through the victim's bedrooms, and in fact it appeared that he was using beer bottles as target practice in his backyard.
Okay, let's separate this. So what's your position on it says it's sealed and we shouldn't consider that? If it's sealed, how did you find out those facts?
Well, what I'm getting to, Judge, is that he had a copy of all the police reports in his apartment, and the Pines Police Department, which did an excellent job on this case, took photos of all of them. So I've got all the police reports.
I understand, but even if they're sealed and a defendant has a copy of what's sealed, does that mean that he's now relinquishing his right to the sealing of the privacy of the patient?
I don't know, Judge. I'm filing a motion to unseal it because it's I talked to the detectives on the case before we even did my detectives talked to the detectives on the case in Dade County, and we were aware of the conduct. My detective contacted the victim in the Dade County case, and spoke to her about the prior incident as well.
Okay, today the court's not going to consider those facts, but go ahead. You were off telling me about some marbles that were found.
That's right, Judge. In addition to the photos that were taken by wildlife cameras, it was actually a pretty creative idea by Pembroke Pines Police. They purchased some wildlife cameras and set it around these houses because Mr. Cerulea was continuing to, for lack of a better term, visit these women on nightly bases. And he, one of the detectives was doing surveillance, and then he finally set up these wildlife cameras with infrared ability to take photos so there wouldn't be a flash. And there we have Mr. Cerulea walking on camera with a Florida State hat on, and of course Mr. Cerulea went to Florida State. We also have him in the burglary case walking through at like 3 o'clock in the morning, or I'm sorry, 5 o'clock in the morning in that case, going through a hole in the fence just prior to and then just after the burglary happened, and that is in the case with AS 1631. In this case with LR, she had purchased, due to the fact that all these incidents continued to happen, and she was not sleeping at night, she was terrorized in her own house, she had purchased her own Nest color video camera that gave us some surveillance video that showed Mr. Cerulea visiting her even in the daytime. And when Mr. Cerulea was walking around her house in the daytime, he was wearing his white button-down shirt that was issued by Travelers Insurance Company and holding a clipboard over the left breast pocket, which is the area that Travelers Insurance has their logo on it.
Let me ask you this. Could you see the Travelers? How did you identify that was a Travelers Insurance shirt? I read that in here. If it was covered up, how was that identified?
It is not your typical polo shirt. It is kind of like a dress shirt that is buttoned down, but it has short sleeves, if the court knows the material I mean. And that shirt was found in his place of business. And also, Judge, one of the videos of him visiting LR's residence is on June 30th of 2015, and one of the videos of him visiting LR's residence is November 2nd of 2015, and he's wearing the exact same thing both days, and that's what he's required to wear at work with khaki pants, and that is exactly what he's wearing in both videos.
See khaki pants in the video too?
Yes,
Are you
Judge.
on probation?
Okay. Let me ask you this. What about the marbles? There's an allegation he's allegedly using a slingshot, I believe, to break glass. There's been glass broken in some of the windows for women. Did you make any comparison or connection between those marbles? What
Yeah.
was broken?
Well, the marbles were actually found after the police were called in most of the cases and were taken into evidence. In 2 of the cases, they were like aluminum ball bearing type hunting marbles, and in the rest of the cases, they were white, small, heavy hunting marbles. My detective testified at the Arthur hearing that he had previously worked for Bass Pro Shops in the hunting section, which is also where he kind of got the idea for the wildlife cameras, and he identified them as the hunting marbles that he used to sell at Bass Pro Shops.
So that marble was found, there was a marble like that found at the scene of one of these incidents, and
Of 5 or 6 of these incidents.
but they were also similar ones found in his own apartment.
Correct. He has a townhouse that has a small backyard, like a cordoned off backyard with a fence around it, and a patio. And one was found, one of these white hunting marbles was found kind of tucked underneath the a portion of the grill, and then 2 more were found underneath the fence where they had apparently rolled, and there was shattered beer bottles in that corner of the fence, and it appeared, at least to my detective and through the photographs, that he may have been using the bottles as target practice in his backyard. Further, we did a search warrant of the defendant's vehicle, which was a Ford that was, I guess, that was issued to him in the course of his work as an insurance adjuster. And in the trunk of that car, we found another hunting marble that was consistent with the hunting marbles at the house and consistent with the hunting marbles that were found at multiple of the crime scenes. We never did find the slingshot, but along with the hunting marble, there was a bag, like a shopping bag full of small gravel-sized rocks that were of a similar size to the hunting marbles. Now granted, Judge, we do not have any information that he was using rocks at any point in time, but I discussed it with my detective, who's obviously familiar with slingshots, and he stated that these rocks could be used for a similar purpose. Also in the trunk of that car, we found a Rust-Oleum bottle of paint, spray paint that was textured, which is the same spray paint, or at least was highly consistent with the spray paint that was continuously being used in an effort to evade the security camera on LR's property. It was a different type of paint than your typical spray paint. I've seen photos of the crime scene. It almost has like a texture or a metallic. It was described to me by the detective as something that you might use in your backyard to spray paint furniture. And actually, when you take stills of LR's camera, even though Mr. Cerulea's face is obscured in most of them, you get a very good shot of the Rust-Oleum can that he was using. And the can is consistent with the can that was being used. And actually, you can tell that the label is gray, which is unlike other labels of Rust-Oleum cans.
Let me ask you this, did you find an FSU hat in his, was an FSU hat found in his house?
Yes. Yes, Judge.
Same type of hat, same logo?
Yes.
As what was on the video?
Right.
Okay.
Due to the fact that we're in Florida and a lot of people have attended UF, that wasn't particularly dispositive, but yes, we did find a hat that was consistent. Correct.
Okay, now, did anybody identify the defendant from the video?
Yes, Judge. There was the surveillance video from LR's residence that was a moving surveillance video, and then the wildlife cameras took stills, but there were multiple stills from each one. Multiple members of the defendant's family identified him under oath to Detective Cabrera, and then when we executed the search warrant, obviously we found some things that were very consistent with the things that we had found at the scene. I was planning on filing a motion for pretrial detention. As to all these cases, obviously, it would have been cleaner for me to get him held no bond on the burglary of the battery, as opposed to going under 907-041. I haven't filed that yet because I have multiple attachments that I'm trying to make, and I'm also going to be making an effort to try to unseal that 07 case, and usually that's held within 5 days of filing, so that's why I've held off on filing that case.
All right. What type of bonds are you seeking though in this today?
Previously, Judge Singal had set $7,500 bonds on all the counts. I had asked him for a higher bond. I would ask the court to set a high bond on this case. I believe that Mr. Cerulli is a danger to the community, he's a danger to every woman within a certain radius of him.
Mr. Pellier, would you like to respond?
Yes, Judge. There's a couple of things that you need to know. On the 31st of December, which is the same date that's on the narrative that you've just read, this is the basis upon which Mr. Cerulli surrendered. He was not, to answer your pointed question insofar as anybody of the victims identifying Mr. Cerulli. The answer is no. What happened is that in this case, rather than performing a lineup or any kind of photo array, what Pembroke Pines Police Department did was issue these particular video stills and distributed them through the media. So the identification that took place was after he had been arrested, because Mr. Cerulli was surrendered by myself to Detective Cabrera on the 31st of December. On the 1st of January, Judge Singal had all of this information that is before you here today. The only dispute that we had was as to the probable cause of the burglary with a battery. Judge Singal entertained all of the very same arguments that were made here today involving the same particular witness by the name of Leslie Reyes. You'll find that the documentation from the December 31st court proceedings identifies her through victim notification, and it's basically the same narrative affidavit. That's right, LR. In addition to that, Your Honor, Judge Singal agreed that there was probable cause on the rest of the charges. We really didn't contest them to get things moving, and he gave a standard bond on all of the charges. Judge Siegel entertained a 2-day Arthur hearing. In fact, we had a hearing yesterday wherein Ms. Bogenschutz and the state put on all of their witnesses, and Judge Siegel, although we were dealing with the issue of burglary with the battery as to the alleged victim AS, he gave the state great latitude to include and argue all of the incident reports, all of the narratives, all of the videos. In fact, that's the reason why I gave Your Honor a copy of the order on the Arthur hearing, where in addition to finding that the state had not met its burden regarding proof, evident, presumption, great, it also references all of the testimony, all of the reports, and all of the material that the court considered in making its ruling. When it made its ruling, it also, the court did, Judge Siegel did, said that it would, or he would be satisfied with a condition level 1 GPS, which we welcomed. He was going to be residing with his mom in Miami-Dade County. He also required, based on the defense's suggestion, that we surrender all travel documents, including United States passports. We went in front of Judge Siegel yesterday to advise him that we were going to do that. We, in fact, did that. And if you look at the court docket on the case that you have, you'll find that all of that has been complied with. In addition to that, Judge Siegel required that there be collateralization of the bond amount that he found. That has been completed as well. Corrections or the folks at confinement are aware that the bond has been posted, et cetera, et cetera. Now, I'm hopeful that the addition of these charges is not sour grapes or retaliation in the wake of Judge Siegel's ruling on the Arthur hearing, but in this particular case, it strikes me as odd that on the 31st of December, they had all of this information, they had all of this ability to file all of the charges that they wanted, and they waited until Judge Siegel entered a ruling that was adverse to the state's position, considering all of the material and all of the arguments, to then come back and have a second bite at the apple, so to speak. Again,
Let me ask you one thing. If you could just respond to this.
Mr. Perez.
Ms. Bogenschutz has told the court that his own family has identified him under oath as to him being the person captured on the videos in and around where these alleged incidents took place.
no, Judge, what had happened is, so that you understand the chronology, and to hearken back to what I said initially, once his photo images were put on and broadcast through the media, that is when, after that, they received information. And by the way, the reports also indicate that they being the Pembroke Pines Police Department, received information that the images that they broadcast on the media were other individuals as well. They specifically named other individuals, but they decided that they were going to focus in on Mr. Cerulia. So there has been no pre-arrest, pre-surrender identification by any of the victims. In fact,
But the point is, though, is without belaboring the point, we could discount the victims or anyone else who saw it on TV that they were prompted because he's the only one they saw on the
right.
TV or whatever. But his own, what I understand, his own family.
That's wrong. That is not correct, Judge.
I have sworn statements from them. Judge.
That
I
is
can
not
show them
correct.
to you.
That is not correct. And again, all of these very same arguments were made through the 2-day hearing that Judge Siegel presided over. So what I would request, Your Honor, in total, according to my math, there's been a $150,000 bond in addition to the other conditions that I've set forth here today that have been satisfied. I would ask that the court use that aggregate amount over these particular 2 charges.
I need to know a few things. How long has he lived in South Florida?
He was born and raised in South Florida. He's lived in Pembroke Pines for approximately 12 years. He has a minor son that he shares parental responsibility with. His sisters were at the Arthur hearing. His mom resides. He's been a long-time gainfully employed individual. I provided Judge Siegel copies of his tax returns, copies of all the information that indicates his long-standing gainful employment, his complying with all legal criteria, et cetera, et cetera, et cetera. So, Judge.
Okay, let me just say, he has family here in South Florida?
Yes.
He has a son. He also has parents or cousins?
His father's deceased.
Okay.
His mom resides in Dade County, which is the location wherein Judge Siegel has directed him to reside during the pendency of the proceedings.
Does he have money in the bank?
He has, I imagine he has some savings, yes.
Okay, can we just ask him how much? I just want to follow the statute before setting bond. I want to check off the boxes. Can we find out how much money he has available to bond out with?
Sure.
Sir, how much money would you say you have either through the bank or investments? How much money would you have available to bond out with?
Sign for an address to the cruiser.
I have several $1,000s in the bank account. I have 401k.
Several thousand, and how much would you say several thousand?
Maybe about 3,000 or 4,000.
How much would you think you have in your 401k?
I haven't checked it recently, but I would assume it's higher than around 20,000 maybe.
20,000, but you got a big penalty if you draw it out. So now,
Judge,
does he own land or property here in South
he owns his
Florida?
home. It's a townhome in Pembroke Pines.
Got it.
And that has been part of the collateralization process that Judge Siegel required. And in addition to that, Judge, so that we're clear, the bond totaling the $150,000 amount for all the charges has been posted.
I understand. Let me ask, does he have a criminal record?
Judge, he has a prior for loitering and prowling, and
when was that?
1990.
Judge, I actually have to correct something that I said earlier.
Okay.
Family members have identified him on the video, because my detective is actually watching the live feed on this and is correcting me at this moment in time. Family members have identified him, but sworn statements were not, they would not give sworn statements, so it's lifelong friends and coworkers that we have the sworn statements of identification from.
Okay.
Just to correct that. And the other thing that I wanted to address was the fact that Mr. Pellier made mention of the fact that this might be some kind of sour grapes on behalf of the state. I had put on the record back in on January 20th of 2016, or 20th or the 21st, when the other 3 cases were filed, that the 4th case had some defects in the information, and I needed to fix those because our word processor had filed the criminal mischief counts as felony criminal mischief, and there was a problem with the dates on the aggravated stalking. She ended up having a medical emergency and was out of the office. And it was on Monday when I realized, after Judge Siegel set the bond and I was checking the system in the jail, that the case as to LR never actually got signed and filed.
Okay.
So that's why that happened.
Let me say, to summarize, this court finds that the circumstantial, there is circumstantial, but then again, there's direct evidence, and that's the ID of the defendant by I think, friends or coworkers who've known him for a long time. The circumstantial evidence in this case seems very strong in the court's opinion too. He's wearing a Florida State University hat. They found a hat similar to that in his own home. Allegedly, one of the victims or a few of the victims had marbles or some type of object like a marble breaking windows. They find marbles in his yard. They find a spray paint can of, what's the brand of that?
Rust-Oleum.
Rust-Oleum in his vehicle. Caught on video as a can of Rust-Oleum. He allegedly is wearing a unique shirt and khaki pants on video. He wears khaki pants, and he has that same type of unique shirt that he wears with his work. So the court does note that there's some very strong circumstantial evidence, and the court also notes, like I say, there's strong direct evidence, his ID by coworkers. And the court is concerned he has a prior lording and prowling, which is really basically what we have here. The court also notes, in the court's opinion, this is looks to be ongoing criminal activity. The court is concerned about the safety of the community, safety of the women of the community, safety of these women in this area. The court also notes there's a certain amount of toying or prompting allegedly by the defendant, going back many times, going back, spray painting. It's a very concerning set of facts that was not isolated, but just ongoing, and it appears there's a certain taunting to these women. Give the court great concern about the criminality or the defendant's his mental state against women or these women, and it looks like several women. And the court needs to give a bond that's appropriate for this court's concern. The court realizes other judges have made certain conclusions, but this court has a unique perception today, or ability to look at the entire case, knowing what the other judges have done, knowing what all the other facts are. The court's going to set his bond on 16 at 75,000, 17 at 75,000. And the court will again order pretrial release, GPS monitor. That will be, what was that, level 1? Pretrial release level 1. And the court will again remind the defendant he's no longer allowed to have any contact with the alleged victims in this matter. Do you want to read off the names of the alleged victims, ma'am?
Yes, they are Amanda Spinner, Leslie Reyes, Chantel Osborne, and Cara Davis.
And he's not allowed to have any direct or indirect contact. He's not allowed to come within 500 feet of them at any time under any circumstance. Defendant's not allowed to possess any weapon. That includes a firearms, a bow and arrow, a slingshot. The defendant's not allowed to have any spray paint in his possession. And I can assure the defendant that if this court has any kind of knowledge that the defendant has, well, he's going to be in the house. He's got house arrest, right? So
That's right.
He's not going to be going outside. So I think that's it. Is there anything else we need to?
Something else from the defense, Judge.
Go ahead, sir.
Based on the court order, Judge Siegel, you'll find that on the last page of the order it says that there's got to be compliance with the passport issue. I understand that there's a confinement representative here. May I be permitted to? Okay. All right. Never mind.
That's taken care of. Okay.
I think it was filed yesterday.
Mr. Pellier, thank you very much for coming to court today.
Thank you, Judge. Always a pleasure.
Correct.
It'll be $75,000 per count. Yes. Okay.
Mr. Pellier, can I see you real quick?
Sure.
Going to go off for about a minute. Scott Long, please. Scott Long, thank you, Ms. Buckley-Shoes.
Judge, can his common law wife come up here? They've been together 20 years. They've not been officially married. They have two beautiful children together.
Common law.
Common.
Okay. All right, I see,
Judge Scott Long is not available. He's a medical reset, please.
you want to reset this for,
Are you available tomorrow morning?
do it tomorrow morning or tomorrow afternoon? What's convenient for you?
Tomorrow morning?
Sure. Do you want to bring you have the kids and the wife or the?
They're not going to testify. I don't know. Can you be here tomorrow, or can I just elicit some brief testimony from her now?
See here,
It's
we're gonna, okay,
it's a misbook.
let me ask you this. Who do we have here?
I'm his pastor. This is his mother. This is his brother.
Okay, and let me ask you this. Are you available this afternoon, or can you come back at 1:30 today? Is that possible?
Yes.
Can you go have some breakfast or lunch and maybe you run some errands and come back at 1:30?
Okay.
Is that possible?
Yes.
Can you do that?
Yes.
Yes.
Okay, I appreciate it. And we'll just come back at 1:30, and that's on Robert, Richard Auguste, and Kamal Rum, all right?
John,
Yeah.
I gave you a corrected report as well. The statute for count one was completed.
On who, Rum? Okay, I'll have that.
Could we know what he's charged with? I don't
He's
know.
charged with, right now, it looks like robbery with a firearm and resisting arrest. The other defendant, Mr. Auguste, charged with robbery with a firearm. So we'll hash all this out. We'll talk about it at 1:30, all right?
Okay.
Now let me
Yes,
ask.
sir.
Now, following people I'm going to ask you to line up: Brenda Rutland, Rachel Harden, Stanley Overfield. Okay, may I see Brenda Rutland?
No.
Okay, Miss Rutland, good morning, ma'am. You have a violation of probation. Your bond's $1,000. Thank you. How about
Thank you. Have a good
Rachel
day.
Harden?
President, the main judge, is there a date on here?
Yes, February 10th at 8:45 in the morning. Thank you. How about Stanley Overfield?
Okay, that's.
Sir, warrant on a traffic matter, 500. Warrant on a misdemeanor, 5,000. Out of county hold, $120. Thank you.
Okay, Judge, one moment, Judge, please.
Okay, we're gonna have to move along.
Judge, I'm sorry. The court needs. Unfortunately, this man is here requesting the court to release him without release him on recognizance. And maybe you can explain to him what I've already explained to him.
You have a warrant out of Charlotte County for $5,000.
Yes.
You have
Yes, sir.
You have a hold out of Sarasota County for $120. You have a hold
I've,
out of Broward County for failing to show up in court. That's $500.
Right, I just discovered about the Sarasota County and the Charlotte County. I didn't know that I had those warrants until about 2 days ago. I asked my roommate to do a little research for me, and he said that he called their courthouses, and they had two options. I could write the judge a letter requesting a new court date and the warrant to be removed, or I could turn myself in and pay the bond.
Okay.
I don't have money to pay the bond right now, and I work full-time and I go to school full-time for nursing. So I'm missing school and work.
Yes, sir.
Being in
Let me
here.
cut to the chase.
Richard!
Your bond's $500 on one, $5,000 on two, and $120 on three.
Mr.
Thank you.
Nolly.
Petrie, Canaan. Violation of probation, sir. That's on a misdemeanor for DUI, Broward County, Judge Robinson, and I believe I was her prosecutor in 1992.
No, he's on the list.
Okay.
Love it.
I don't remember this gentleman now. But,
Yeah, because, like, well,
sir, I'm gonna go ahead and,
hold on.
Mr. Antti Kanan, sir, you live in Finland.
That's correct, Judge.
Wait, where'd they pick you up at the airport?
Yes.
Oh, boy. All right, let me see here. Hold on a moment. When are you going back to Finland?
Well, 14th of February.
Well, he's already got a, he already has the criminal record, and apparently that's not preventing him from going in and out of the United States. Sir, if you want to admit you violated probation today, here's your option. Option one, you stay in custody to February 8th, and you'll see your judge on February 8th and resolve it there. Or today, you can tell me you admit that you violated probation. It's like pleading guilty. You say, Judge, I violated probation, and I want the case to be over with. That means you're not going to have a hearing in front of your other judge. You're not going to have your day in court. It's wrapped up right now. What would you like to do?
I'm guilty.
You admit you violated probation?
Yeah,
I'll
yes, I
revoke,
did.
give you time served. Good luck.
You're done.
I didn't have the heart to send it back to Finland with this thing still open. You know what I mean? All right.
Thank you, Judge.
John Schultz, Jonathan Nelson, and Nerville Bartholomew. Okay, where is Schultz?
I spoke with Mr. Schultz's attorney this morning. He'd like to reset this case to tomorrow afternoon, please.
Okay, so we're gonna set this for Friday PM.
Okay, thank you.
Okay, Jonathan Nelson. Mr. Nelson, Sir, you have a warrant on a misdemeanor, and that's no driver's license. Hold on, Mr. Nelson.
Maybe keep that noise down.
If the court's interested, Mr. Nelson would like to resolve this if he can.
Okay, let me look here. No driver's license, ID card. Sir, if you want to plead no contest, case is over today. You're not going to have a trial. You're not going to have your day in court. It's wrapped up right now. Is that what you would like to do?
Verbal?
Yes.
How do you plead, sir?
Non-contest.
How do you plead?
No contest. No contest.
I'll accept that. I'll withhold adjudication. Good luck. Nerville Bartholomew.
Good luck to you, sir. He's president of the main jail, Decline PD. Also would like to resolve this case if he can.
Mr. Bartholomew, you're here for, you have a valid DL. Failed to appear in court a bunch of times. You want to resolve this today? No driver's license. Case is over with today. You're not going to have a trial. You're not going to have your day in court wrapped up right now. Would you like to do that?
Yes, Your Honor.
How do you plead?
No contest.
I'll withhold adjudication. Good luck, Mr. Bartholomew.
Good luck to you, sir.
How about Ulysses Belate, Sean Mackey, Robert Barnes, and Travis White?
Belate is it, Conti?
19, sir, you have a warrant on count 19. That's $1,000 for possession of ethanol. Thank you. How about Sean Mackey? Thank you, sir. Your bond's $1,000. Sean Mackey.
Huh?
Sean Mackey, sir, count 4 and 5 are warrants on felonies. Criminal use of personal ID, unauthorized use of personal ID. Those are 1,000 per count. Thank you. How about Robert Barnes? Robert Barnes.
Yes, Your Honor. Good morning.
Robert Barnes,
Morning.
count 3 is a warrant on a felony. Good morning. That's
Good morning. How are you?
Your Honor,
just fine, Mr. Barnes.
printed out. This was a change of charge from a Bergbat.
Wait, Barnes? Count 3, the felony
I have
petty
the
theft.
Bergbat on my. See, this is what I'm really getting confused by, Your Honor. On my booking sheet,
Right.
it has Bergbat also. Has a change of charge? No, it was changed to burglary with a mask. One moment, Your Honor. Oh, shoot. Let me just. What? One moment, Your Honor.
Sir, were you working before you were arrested?
Was I working?
Yes.
Your Honor, if I.
I'm disabled, Your Honor. I collect disability.
Do you have any money in the bank?
No, all I had was $1,000 I put up for the bond.
How long have you lived down here in South Florida?
52 years, sir.
Whoa.
Do you have family down here?
Yes, sir.
Okay, and who do you have down here in South Florida?
I have 2 sisters. I have cousins and nephews.
Do you own any
My mom
land or
passed away.
property down here?
No, sir.
Okay. Do you have any financial resources to bond out of jail, sir?
No, only the $733 I make a month from disability.
Okay.
Like I said, I did put the $1,000 up.
I understand.
That was it. Okay, thank you.
This is.
Every time you look at it's perjury. Okay, have a seat.
Okay.
So,
go ahead.
Oh my God. I would note, first off, that I guess this allegedly occurred January 2nd. He wasn't arrested immediately, obviously. But Your Honor, he has another pending grand theft. From what I can see, 5 days after this allegedly occurred, he was arrested stealing a grand theft amount at a department store, at a Walmart. Additionally, Your Honor, his priors include 2009 possession of cocaine, 2008 possession of cocaine, alprazolam, caresprodol, oxycodone, theft. He had a grand theft in 01 with the VOP and a possession of cocaine in 87 with the VOP. Year and a day. I would also note, Your Honor, that because it really didn't have to be taken into consideration, the first time he came through, it was just a finding of proof evident or presumption great.
Case number?
Well, no, he didn't violate.
Okay.
What happened was he hasn't violated releasing conditions, Your Honor, but I would note, he broke into someone's home and mentions that her children, and I'm just making a record, Your Honor, I know you've seen the report. Children were asleep, and the victims, I believe, is her mother, were asleep in the home with medical issues, Your Honor. We broke into this home.
Sir, the court's going to set your bond today at $75,000, pre-trial release, GPS monitor. It's going to be level 1. The court's concerned not only for the safety of the alleged victim in this case, a single woman allegedly asleep in her bed. You allegedly break in her house. You have a syringe on you. You left your shoe there. They were able to track you down. She identified you. The court's very concerned about the safety of the community. You'd be willing to go in a home with a single woman there at night while she's sleeping. So your bond $75,000. The court also notes you have a lengthy criminal record, and the court took that into consideration also. Thank you. You're not allowed to have any contact directly or indirectly with the alleged victim. And do we have her name? Gwendolyn Cash, I believe. Is that it?
Yes.
Gwendolyn Cash. No contact. Stay 500 feet from her.
Just to clarify, count 1 is not on the docket.
Well,
Thank you, Your Honor.
It should be. He's entitled to a bond.
should I
Now.
change this to count 1 is from count 3 here?
No, Your Honor, because he does have a
Okay.
count 3.
There you go. I'm leaving it. There you go. Travis White.
Main jail.
Sir, count 6 is a warrant on a felony. That's for that's a change of charge. That's a grand theft firearm. And your bond is $1,000. Thank you. Now,
Good luck, Mr. White.
I see Jessica Duplessis. Jessica Duplessis. Right there, sir. Just right there. There you go. Ms. Duplessis, purchasing cannabis. Just step right up to the. There you go. Purchasing cannabis. Finds probable cause. We have somebody here on your behalf. Can you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Tell us your name.
Jean Duplessis.
Hand down. How do you know Jessica?
That's my daughter.
Your daughter?
Yeah.
Excuse me. Steve, does she have a criminal record?
Loitering and prowling that you pled out last November.
No.
Let me ask you something. Is your daughter, I see that she is 18 years old. Is she in school right now?
No, she did.
She's supposed to go to school right now.
Today?
I just bring her to school, the Atlantic school.
She go to high school?
She going to.
Where does she go to high school?
She quit, and then she gonna have to start over.
Wait. Let me back up. Is she in school right now?
No, she was stopping, and then we bring her to Atlantic Tech School.
What happened? Did
Registered last week.
Did she stop going to school?
She was stopped going to school.
All right. And how long has it been since she went to school?
She started going to, they sent her to special school in Pompano.
When?
And that was, I would say 7 months ago.
So, does she work?
No, she don't have a job. She got a private job she's doing.
What does she do all day? She doesn't go to school. She doesn't work.
Last week I bring her to school
Right.
to register at Atlantic Tech School, and then she got a test and she waiting on the school.
Did she go to school this week?
No, she didn't go to school this
Why
week.
didn't she go to school this week?
She has to go when they call her.
Judge, I think I can shed some light here.
Go ahead.
my client's advised me that she's enrolled in Atlantic Technical College for her GED. She has to take an entrance exam before she can get placed into the class. But she is registered. She's ready to go, and she intends to go back and get her GED.
Ma'am, I'm going to release you on your own recognizance. You're going to have a pre-trial release GPS monitor on you. You're going to have a curfew every night. You need to be in your dad's house by 8 p.m. every evening. You can't leave the house until 6 a.m. You're going to get drug tested every week. If you fail a drug test, you're going to be rearrested. Now, let me explain to you, ma'am. You're allowed to leave the house to go to school, to go to the doctor, to go to work. But other than that, you're not allowed to leave the house, all right? Do you understand, ma'am?
Yes, sir.
And once work is out, once school is out, you'll have, or the doctor, you'll have a half an hour to get back home, all right? You
Judge,
can leave a half an hour before, and you have to be back at a half an hour after it's out, okay? Thank you.
Judge, I'm not going to object to the curfew. I think that probably makes sense under the circumstances. But to put a GPS monitor on a first-time offender for a simple possession charge, Judge,
Yes, sir.
isn't that a bit of overkill? Can we?
No,
I mean,
the court,
give her the curfew, let Dad turn her
the
in.
court wouldn't have done it. The court thinks it's appropriate for a girl like this who's was in trouble just last year. She's 18 years old. She's in high school, and she's out allegedly dealing in drugs on the street. The court thinks it's very appropriate to keep an eye on her, to keep a thumb on her, so she doesn't go out and continue to behave in this manner. Thank you.
Your Honor, if I may.
And also, the court's letting her out of jail free. We're not even charging her. No bond required. I want to make sure that when she's 28, she's 18 now, she's doing something productive, and she gets away from this drug crowd, and she gets an education, and I don't want her to be a criminal. I want her to get her life together, and I hope I put an ankle monitor on her. We can keep our thumb on her and make sure she doesn't continue to behave in this manner. Thank you for coming to court.
Your Honor, just very briefly.
No bond required. GPS all
Just
the
to
way.
explain the court real
Go
quickly. I reviewed it. The loitering and prowling from last year, her and some friends at about 7 o'clock at night went into someone else's house to quote unquote hang out. So
Right.
it appears that there
What
are
do I do
some.
from now? Because
She'll be out of jail this afternoon or this evening. You go pick her up right next door here, okay?
Okay, thank you very much.
Sir, thank you very much, okay? Take care. Hey, sir.
Stopping things before they get.
Julius Caesar. What? Julius Caesar. Do you have Julius Caesar over in the jail, Mr. Miller?
I don't know, Judge. What page? You know what page he's on, Judge?
Don't know. Julius Caesar.
Paul Ryan, can you hear me?
There you go.
There you go. All right, Mr. Caesar. Count 4,
Yes, sir.
license suspended, 750, resisting arrest, no bond required. 6 and 7 are probation violations. Thank you.
Excuse me, sir.
Yes, sir.
You said there's an ad charge. You said?
Yeah, probation violation and license suspended, all right?
Okay. Could I ask for a possibility of pre-trial release because I have no assistance on the outside on helping to fight this case or gathering evidence.
I understand your request, but I'm going to let you go see your judge on February 11th, all right? Thank you. How about Lazar Rodriguez, Christopher Lefebvre, Anthony Barlow, and Carlos Ramirez Martinez?
They call your name, line up, all through those shirts.
Lazar Rodriguez.
When? Tuesday at 8:30. Bring
No bond violation of probation. Christopher Lefebvre. 2 violations of probation, Mr. Lefebvre. They're both no bond. Thank you. Missy Anthony Barlow. Anthony Barlow, count 1, a warrant, no bond. Count 2, violating probation, no bond. Carlos Ramirez. Mr. Ramirez, violating probation. Are we on? Yeah, we're on. Violating probation, $10,000, sir. Thank you. I see Willie Becklum, Alan Jover, Ian Hernandez. Willie Becklum, sir, violating parole, no bond. Thank you. How about Alan Jover? Mr. Alan Jover, violation of probation, no bond. Thank you. How about Ivan Hernandez? Ivan Hernandez, please. Mr. Hernandez, violating probation, no bond, writ of arrest, $1,000. Robert DeVella, Charles Commander, Huey Hodges, please come forward. Sir, violation of probation, DeVella, no bond. Thank you. How about Charles Commander? Violation of probation, that community control, $15,000. Thank you. How about Huey Hodges? Sir, violation of probation, violation of probation, no bond. Thank you. Okay, following people, please line up when I call your name. Ziamara Mendez, Christine Malik, Rose Perez, Victoria Augenbaugh. Okay, Ziamara Mendez.
This is Miss Mendez, Judge.
Hi, ma'am. You've been charged with DUI. This is your first offense. Court finds probable cause. State, she have a criminal record?
Yes, Judge. 09, possession of cocaine. 08, drug paraphernalia. 07, contributing to the delinquency of a minor. 04, felony criminal mischief. 2, battery. Looks like DUI property damage.
Leaving scene of crash. Ma'am, are you working at this time?
Judge, Miss Mendez works at McFadden. Actually, she's a student at McFadden. She's studying drafting. She's due to finish that program in June. She's a 38-year resident with strong family ties, no money to post her own bond.
You got it, ma'am. I'm going to go ahead and set your bond at $500. Just based, you actually have a prior DUI. We're not going to count towards your bond. Your bond's $500. Thank you. How about Christine Malik?
Main jail. Judge, we have an argument.
Okay, Malik, trespassing. What's the argument?
Judge, I read the probable cause affidavit for Miss Malik, for Mr. Bannon-Zach on page 11, and Mr. Carver on page 11. They're all alleged to have been trespassed under the same police report. Basically, what you have is a cut and paste where they just changed the name in the last sentence of the probable cause affidavit. I don't believe that it's a normal operating procedure for the police department to put more than one person on a police report. And so I would argue that this affects the reliability of all of these police reports and that there is no probable cause based on the police basically cut and pasting the information in the case.
The court notes your argument, your position, but the court will find probable cause. State, are there priors on Miss Malik? Malik, ma'am, would you like to resolve your case today, Miss Malik, and plead guilty or no contest? You'd be out of jail today. Ma'am, the only thing is you're not allowed to return to the Taco Bell on Commercial Boulevard. You can't go back there. Is that clear?
Yes.
All right, ma'am.
Yes.
How do you plead?
No contest.
I'll withhold adjudication. Good luck, Miss Malik. How about Rose Perez?
Judge, I got an argument.
Your Honor, I'm going to be asking for this to be reset for the afternoon anyways. It doesn't mention anything about armed. I suspect it's a misbook, but I just want to be able to confirm with the
Okay,
officer.
I'm gonna reset this matter for 1:30 today. Bring Ms. Perez back at 1:30 today. Thank you.
What? Get over here.
How about
Yeah,
Victoria?
we still need a photo order for her, Mr. Officer, please.
Victoria Augenbaugh, grand theft.
Main jail, decline PD.
Court finds probable cause, allegedly. Do we have any Crown Plaza Hotel?
She has a warrant for a probation violation out of Arkansas.
Right.
From 2014. Looks like it was a drug offense that she's on probation for.
Out of where, Arkansas?
Yes, Arkansas.
And she's on drug probation from
Interesting.
2014?
Yes. Additionally, Your Honor, the reason she's here,
Right.
she was arrested in Sunny Isles on January 26th
Right.
for grand theft. That's when they saw the not in custody warrant out of Broward, brought her here. So it looks like she's got an open theft charge. It would appear she has an open grand theft out of Dade right now also.
Okay. Anything else?
I've just seen if there's anything else out of, 2012 out of Arkansas, shoplifting. And just the case she's on probation for.
All right, ma'am. Ma'am, how long have you lived in South Florida?
Almost 3 years, sir.
Okay, are you currently employed?
I dance.
You dance?
Yes, sir.
Okay, and do you have any money in the bank?
No, sir.
Okay, and do you have family here in South Florida?
No, sir.
Do you have any cash, any money not in the bank?
No, sir.
Okay, do you own land or property in South Florida?
No, sir.
Ma'am, it's alleged you stole from a hotel room a man's presidential watch, Rolex, $20,000, a diamond ring, I believe, $15,000, another diamond gold bracelet, $5,000. So it looks like allegedly you got him for $40,000. Ma'am, based on your criminal record, the facts of the case, it's going to we're going to set your bond today at $10,000. And you can bond out and based on your criminal record. Thank you, ma'am. How about Henna Bramer? Where's Miss Bramer? She have any prior statement, Bramer?
Page 5, Brammer. Bonded, Judge.
Bonded? Okay, what about Leslie
Duncan.
Duncan?
Come on. Judge, we're looking for pretrial release for Miss Duncan.
Hi, Miss Duncan. How are you?
Hi, Your Honor. I've
Miss-
straightened out my life. I want you to know that I've not been in front of you in a long time, and I'm getting my children back. And
Well, that's
is there any way you could give me pretrial?
You remember,
Does he give me
it was that 7-Eleven on Sunrise Boulevard for a long time, wasn't it? Didn't you get
No.
arrested there?
No, that wasn't me.
Oh, I'm sorry. Okay, it's grand theft. Court finds probable cause state to Chef. When was the last time Ms. Duncan was through here? Ms. Duncan, do you have any money in the bank?
No, she was arrested in
No.
2015.
2014 is the last time that I had anything.
Do you have money in the bank?
I don't have any money in the bank right now, but I'm an eligible candidate for pretrial release.
How long have you lived down here in South Florida?
10 years.
Okay, do you have family down here?
My family's not here, but my boyfriend
Got it.
is, and
When was the last time Ms. Duncan came? She allegedly stole from Sears, caught on closed circuit TV, $505 worth.
Last time she came through was last year on a capias
Okay.
for failing to appear in court on a possession of cocaine case.
Okay. 35 arrests? Okay, but when was the last one?
That's what I said last.
No, I mean last case, you have a last time she was convicted or?
Yeah, she ended up, the cocaine she was arrested on the Cape, she ended up pleading out on May 20th to 364 days.
And that, what case was that? I mean, was that a 14 or a 13?
It was a 2014 case.
14 cocaine. Ma'am, your bond today is going to be $1,000 based on your criminal history. Don't
Mental
go back
health
to
screen.
Sears. Thank you.
Mental health screen,
Judge,
Judge.
did the court consider pretrial with the BART component?
No, sir, not today. We're going to leave it the way it is.
There's a bark.
Duncan
If I
has
get a bark, you won't let me get a
very lengthy
pretrial.
arrest record that we're aware of. So, okay, thank you, ma'am.
Can we get a SAP order for
Sure,
Ms.
I'll
Duncan,
order a SAP
please?
for her. Thank you, ma'am. Okay, what about Maria Mitchell?
Come on. Mitchell?
Miss Mitchell? Hi, ma'am. License suspended, Miss Mitchell. And count two's probation violation. I do see her license is going to pay some traffic fines. Failure to appear in court.
Exit court.
Okay.
Judge, is count 2 based on a warrant, or is this a 948?
Where? 948, I believe.
Judge, I would ask the court to consider setting a bond in this case. The stop, I believe, was questionable. It's alleged that a license plate reader caught a license plate that may have been registered to her, but there was no identification of her as the driver prior to the stop, and that would make it an illegal stop, and it's actually suppressible. So I'd ask the court to go ahead and set a bond in this case and allow her to fight this thing from the outside.
You know what? She's got failures to appear on her driving record. That's what the court's hesitant about. Ma'am, I'm gonna reduce your bond on count 1, but I'm gonna let you go see your judge on count 2. All right? Count 1's 100, and you can go see your judge on count 2. Thank you, ma'am. Isis Gorley.
Medical research.
Okay, we're gonna set Miss Gorley for Friday p.m. Thank you. What about Paula Sutton? Good morning, Ms. Sutton. Petty theft, illegal use of credit cards. Court finds probable cause allegedly from a CVS, purchasing gift cards for $104, confessed using victim's credit card, and a gas station. Caught on surveillance video. State, does she have any criminal record?
2014, possession of cocaine with a VOP. 2014, prostitution. 2013, possession of cocaine with a VOP. 2010, possession of oxycodone with a VOP. 2003, possession of cocaine with a VOP.
Got it. All right, ma'am. Are you currently employed?
I was supposed to start a job today.
Do you have any money in the bank?
No, I don't, sir.
All right. How long have you lived down here in South Florida, ma'am?
42 years.
All right. I'm going to set your bond on count 1 at 500, 2 at 1,000. Based on your criminal record and the facts of the case, excuse me, you can bond out. Thank you. How about?
What was the bond?
$1,500, 1,500. Thank you. Letitia Reeves.
Main jail judge, we have an argument.
Ma'am, you're charged with neglecting a child without great harm. Go ahead. What's your argument, sir?
Judge, in order to neglect a child according to the statute, the caregiver has to fail or omit to, quote, provide a child with care, supervision, and services necessary to maintain the child's physical and mental health, including but not limited to food, nutrition, clothing, shelter, supervision, medicine, medical services that a prudent person would consider essential for the well-being of the child. According to the probable cause affidavit in this case, the child was in the back seat. It doesn't say she was in a car seat. However, it doesn't say she wasn't in the car seat. So we're going to say that she was in the car seat. The car doors were open. She was standing right by. She was not involved in the altercation that was going on. She was simply videotaping it. She was not neglecting this child. Judge, there is no neglect here. There is no probable cause to hold her on this charge. I'm going to ask the court to release her on her own recognizance.
I'm going to look at the statute like you did, but I thought the statute said it has a clause in there, or like a potential. You put your child in a situation which could potentially cause harm, or likely to cause harm. That's what I. 827.03. 03 TV.
Judge, that would be child abuse, not neglect.
Caregiver's failure or omission to provide the child with the care, supervision, and services necessary to maintain the child's physical and mental health, including but not limited to food, clothing, shelter, supervision. Supervision's one of them.
Judge,
That
go ahead. I'm sorry.
a person would consider. Okay, caregiver's failure to make a reasonable effort to protect the child from abuse, neglect, or exploitation. Neglect. We know negligence, a duty to do something and not doing it, and the court believes that.
And Your Honor, what you're referring to
Judge, may I be
is-
heard before the court makes a ruling?
Right.
Okay, there is no allegation in this probable cause affidavit that she was anywhere, that she was never within sight of this car. Okay, the police officer made a big deal about the car being open. Both doors were open. It's 79 degrees. This is no different than pushing a child down the street in a stroller. Judge, I'm arguing that there is nothing in this PC to rise to the level to felony child neglect. She didn't do it. The child was in a car seat. The car door was open. She was standing right by the car taking videos. Judge, there is no probable cause to hold this woman on this charge.
Sir, the court respectfully disagrees that a woman would drive or be a part of be in a vehicle to go to a location to get into a fight with another woman, taking her 19-year-old child with her, having it videotaped. Yes, the court does believe that taking your child to a fight where two adults that they know are going to fight to settle some type of grudge is most likely probably neglecting your child. The court's going to find probable cause.
I just want to,
record.
and Your Honor, I just want to note also, because I don't know what's going to happen from this case, the language the court was referring to is also included in the definition. It just comes next. And I just would note my own argument, the comparison to pushing someone down a stroller. I would argue if someone stopped pushing their 19-day-old child with a stroller and instead decide to go and divert their attention somewhere else to videotape something else, that certainly that child in the stroller could be put in harm's way.
From what we could see, the child was left in the car while this fighting and videotaping was going on outside of the vehicle, and that's what the court's looking at. Now, does she have a criminal record?
Checking that right now, Your Honor.
Mr. Miller, is there anything you'd like to say on behalf of this defendant's ability to bond?
20-year resident of South Florida with strong family ties, including her mother, her grandmother, her entire family. She has a job. She works at Macy's. She's a registered voter. She's going to be asking her family to bond her out.
I understand. Now, she has no criminal record, ma'am. I'm going to do this. I'm going to release you today on your own recognizance. I hope we can chalk this up to poor judgment on one occasion. And I do have a duty to contact.
I'll contact the officer to see if they
services. And I need to appoint a guardian ad litem, which I think I've already done. Thank you, ma'am.
Crystal.
All right. How about Crystal Babineau? Okay, Ms. Babineau, burglary of a dwelling and grand theft auto. The court finds probable cause. Do we have a criminal record on Ms. Babineau? 2010 DUI. Okay, do we have any, Ms. Babineau, how long have you lived down here in South Florida?
Judge, I'd like to make my argument.
Go ahead.
Judge, according to the probable cause affidavit, the only thing that Ms. Babineau did was drive someone to a place where she went to recover some of her property. Somebody else committed a burglary that she had no knowledge of. Somebody else committed a grand theft that she had no knowledge of. I don't believe that there's a statute that requires a person to turn a person in who's committed a crime. If she found out later that this person committed a crime, she has no duty to report that. There's no nexus between what these two people did, one of whom was unknown to her, and what she did. She just simply went to pick up her stuff and then drove away, not knowing what occurred inside the house. I'm arguing there's no probable cause. She should be released on her own recognizance.
Yes, sir. Well, the court disagrees today. The court believes that there's ample evidence that she acted as a principal while she stood by and watched one man break into the residence of someone else, ransack the residence, come back with belongings of the homeowner, get in her car, and she drove and had a meal with the man. So it does appear that she at least gave him a getaway ride. And as far as the grand theft auto goes, that was all part and parcel, stealing the Harley Davidson of the initial acts allegedly by Miss Babineau and the other man. And then the court notes that the man who allegedly stole the Harley Davidson actually went and had a meal with Miss Babineau after stealing it. So it does look like
Judge,
they're all
we're
part and
taking into
parcel of the same
consideration the
criminal
fact
acts.
that the break-in took place at the back of the house, and she was in the front of the house.
Yes, sir.
So she had no idea that the house was being broken into.
Well, you know, it doesn't. The facts, in this court's opinion, look like she did. She was all a part of it. But go ahead.
She knew she didn't have a key. Her key wasn't working.
Right.
He's getting in somehow.
Right. So go ahead and state this. Do you have a criminal record? You already told me. DUI in 2010.
Correct.
Anything you want to say about Miss Babineau's ability to post bond, sir?
Judge, she's a 7-year resident in South Florida. She has money in the bank, however, she has no ability to access it. We'll ask the court to release her on her own recognizance on all accounts.
Okay. Ma'am, do you have family down here in South Florida?
She does not.
No? Okay, ma'am. I'm going to go ahead and on the burglary of a dwelling, set your bond at $3,500, and on the grand theft auto at $1,000. Your total bond's $4,500 based on the facts of the case and your criminal record. Thank you, ma'am. May I see Heidi Mulligan?
North Broward.
Okay, Ms. Mulligan, possession of heroin, count 1. That bond's $1,000. Count 2 is a violation of probation. You'll be held without bond. Thank you. How about Leisha Butler?
May jail, we have an argument.
Okay, possession of 2 unlawfully issued driver's licenses and resisting arrest without violence. What's your argument, sir?
Judge, as to count 3, resisting without, it does not appear that the defendant resisted the police in any way. It does not say that she did not, in fact, give the police officer her name, which is the only legal obligation she has. The rest of this, whatever she said verbally, cannot amount to a resisting arrest. And so I would argue there is no probable cause for that. As to counts 1 and 2, Judge, in the probable cause affidavit, it says quite plainly that she was in possession of 2 driver's licenses, not 2 false driver's licenses, not 2 fictitious driver's licenses, not 2 stolen driver's licenses, or unlawfully issued driver's licenses. In possession of 2 driver's licenses, that does not fit the elements of this statute. There is no probable cause to hold her on this charge.
Okay, the court agrees with count 1 and 2, disagrees with count 3. The court believes that once she's placed into custody, her behavior was definitely resisting arrest. In the court's opinion, count 1 and 2, she's going to be released on her own recognizance. And then, Steve, does she have a criminal record? 2010 strong arm robbery. Ma'am, do you have any money in the bank?
She also has adjudication for grand theft.
Okay.
She has other priors.
Ma'am, do you have any money in the bank?
Judge, she's a lifetime resident with strong family ties, including her mother, her grandmother, her sister, all of her family. She works at Liberty Tax. She has no money and no one to help bond her out.
Ma'am, your bond on 3 is $100. You can bond out. Count 1 and 2 are ROR.
Thank you, Judge.
There you go. How about Gay Diamond? Gay Diamond?
North Broward.
Yes, Judge.
North Broward.
Hi, Miss Diamond.
Hi, how are
Hi,
you?
ma'am. Good. Order for prostitution, count 1, 302, possession methamphetamine, 1,000. 3 and 4 are probation violations. You'll be held without bond. Thank you. How about?
What are 3 and 4?
Those are probation violations, ma'am.
You got VOP.
You're on probation right now.
Correct, yes, 2 months more.
Right. Thank you.
And, okay.
Carissa Burnham,
Bonded.
bonded, okay. Now we're going to the mail portion of the docket. Okay, let's see, Jose Perez, line up. Jermaine Lambert, line up. Ty Williams, Philip Bryant, and Glenn Ebersbach.
Your Honor, already reset Mr. Perez to tomorrow morning.
Okay.
And this is Mr. Lambert. He would like to resolve this case if he can.
Friday AM on Perez.
Write that down for me.
Here you go. Lambert, trespassing, sir. You want to plead no contest? Case is over with today. You're not going to have a
Yes,
trial.
sir.
It's wrapped up right now.
I want to get it over with, sir.
How do you plead, sir?
No contest, sir.
Okay, sir, I'll accept that. You're not allowed to return to USA Grocers. All right? Thank you.
Yes, sir. All right.
Full adjudication. How about Ty Williams?
North Broward.
Okay. Hi, Mr. Williams, sir. Petty theft, count 1. That's 25, count 2. Petty theft, warrant 500. Thank you. How about Philip Bryant?
Judge, it's North Broward. I'm going to ask for a mental health screen.
Okay. Court will order a mental health screen. Sir, count 1 is criminal mischief, 2 resisting arrest, 3 trespassing. Court finds probable cause. You have a criminal record state. Mr. Bryant, are you currently employed?
Yes, sir.
What type of work do you do?
I work at Checkers.
Do you have any money in the bank?
No, I don't.
Do you have family down here in South Florida?
Yes, I do, but I don't associate with them.
Who's going to bond you out of jail today?
No one.
Okay.
I don't
Last
have
year-
anyone to help me right now.
Last year, 2 counts of resisting without violence and trespass. Resisting without violence, 2013. Grand theft, uttering, 09.
Sir, your bond's $1,100 on count 1. You can bond out.
We need to go back.
Well, let's finish this one first.
I understand that the court let him out.
Right.
So, the court's not inclined to rule.
No. There you go. Thank you. How about Glenn Ebersbach?
Judge, this is Mr. Eversback. He's interested in resolving this case if the court is so inclined.
Sir, commercial use of state right-of-way. Court finds probable cause. State, does he have a criminal record
His last arrest in Broward was January 8th.
of this year?
Yes.
Okay, what was that for?
Commercial use of state right away and a capias on a battery.
Okay, so,
It's released January 19th, and it was in the same location as this
so
arrest.
he's, okay, so he's second arrest in a month for panhandling at the same location.
Yes, Your Honor.
All right. Anything else?
October 27th of last year.
Got it.
That was on the battery case that he got picked up on for a capias.
Mr. Miller, Mr. Eversbach, do you still live on Northwest 16th Street in Pompano?
Yes.
Okay, how long have you lived there?
About 6 months.
Okay, Mr. Miller, anything you want to say?
No, Judge. I was hoping he could resolve it.
No, we're not going to resolve it today. Is there anything you want to say on behalf of this defendant's ability to postpone?
Judge, I did not interview Mr. Eversback because I thought he would be resolving his case.
Right, well, we're not going to resolve it today. Is there anything you want to say on
I understand that. If the court wishes to inquire, I have no objection.
Okay, Mr. Eversbach, do you have any money in the bank?
No, sir.
How long have you lived down here in South Florida?
30 years.
Do you have any family down here in South Florida?
Not anymore.
Okay. Do you have any ability to post bond today?
No, sir.
Sir, I'm going to set your bond at $250. This is the second time in about a month you've been arrested for doing the same thing at the same location. Thank you. You can bond out. I see Billy Goings.
North Broward.
Goings is a med reset.
Okay, we'll set Goings for Friday AM docket. There you go. Now let's set that for PM. PM done. There you go. Hey, what about Wayne McGetchie,
Maine.
David Banaszak, Kenneth Carver?
Judge, Mr. McGeechee would like to know if the court could release him on his own recognizance based on the fact that he turned himself in on these warrants.
Okay. That today will not occur. However, sir, let me advise you, your bonds on count 1, 2, 3, and 4 are $2,000 per count, and count 5 is $500. Thank you. You'll see your judge on the 9th. Thank you. How about David Banaszak?
President of the Maine, we have an argument.
Sir, you're here for trespassing. Go ahead.
Judge, according to the statute, Mr. Banaszak would have to have been warned about trespassing. In this case, there is no evidence that he is warned. The police report that's listed in this probable cause affidavit applies to Christine Malik and not to Mr. Banaszak. Therefore, there is no probable cause that he committed a trespass, that he was properly warned to leave the property. And I would ask him to be released on his own recognizance.
And it does refer to him as she. I mean, it's poorly written probable cause affidavit. I would ask the court to ROR.
Spoke to the shift leader, rear of the parking lot, stated the subject was not allowed on the property. Trespass affidavit is on file to this location. There are signs posted no trespassing as well. A copy of the affidavit. Okay, I'm going to go ahead and, where's Banaszak?
He's in a holding cell, Judge.
I'll release Banaszak ROR. Thank you.
Thank you, Judge.
How about Kenneth Carver?
Main jail, same argument.
Okay, I'm going to release Carver ROR. Thank you.
Thank you. Thank you, sir. Good luck.
Thank you. Let's see, Gene Doristil, Fritz Walter, Rigoberto Ortolana Benitez, and Daniel Robinson.
Judge Doristil is president of the Maine. He'd like to resolve this if he can.
No driver's license, Mr. Doristil. Hold on one moment. Okay, he's got an ID card, multiple failures to appear, failures to pay traffic tickets. I've got 4 pages worth.
He's got an open, no valid right now out of Miami.
Right. Sir, are you currently employed?
I work at dry cleaner, sir. Sutsy's dry cleaner.
Do you have any money in the bank?
Not at this second, sir.
Sir, I'm going to say your bond at $250. You have an open, no driver's license now. Thank you, sir. How about Fritz Walter?
Good luck.
Can you request a phone number?
President of the Maine, he would like to resolve the case if he can. What do you?
Okay, Fritz Walter, come on up, sir.
He was just.
Judge, I'm sorry. Mr. Doristil would like this court to sign an order allowing him access to his phone. So
Sir, you can have access to your telephone. I'll allow that. Okay,
Thank
what
you.
about Fritz Walter?
Stand up at the podium.
Come on, Fritz.
When's the last time Fritz Walter was in the state?
Last week.
What was that for?
County ordinance open container.
What was the date?
January 25th, Monday.
So 125, I'm sorry. 125, open container. What about before that?
December 24th last year. Disorderly conduct.
Okay.
July 9th last year.
When?
July 9th.
When was
Trespassing in open container. And June 30th. Trespass.
Okay.
June 24th. Resisting. 24th was resisting without violence. June 18th, sleeping on the beach. Guys. June 9th.
Okay.
Open container. Then April, Bat Leo that he was county sentenced on.
What was that?
A Bat Leo.
What was the date?
April 17th of last year. Then April 13th last year. municipal ordinance. I don't know what the offense was.
Okay, well, it looks like he's been arrested. I mean, we haven't even written them all down. 1, 2, 3, 4, 5, 6, 7, 8. 8 times in the last, All right, so, I'm gonna go ahead. Sir, do you want to say anything? I'm gonna send him over to Judge Lerner Wren, all right?
Sure.
Judge,
I didn't hear you, sir.
We're gonna set his bond at $100. We're gonna send this to Judge Lerner Wren. And, thank you, Judge Lerner Wren. I have an order. Thank you. Rigobirito, Orellana, Benitez.
Call Ryan, Your Honor. He needs a Spanish interpreter.
Okay.
Out the door. Outside.
What about Daniel Robinson?
Yeah.
Daniel
North
Robinson.
Broward.
Your Honor.
He's a mad reset, Your Honor.
We're going to reset him for Friday p.m.
Your Honor, just to let you know, he's being held on count 1 on a carjacking.
Right.
Where a bond was set by Your Honor at $125,000.
Right.
This is just additional charges to that count.
Right.
What's this? Hello?
Okay, Friday p.m. on that. Did you call Spanish?
Well, he's being arraigned tomorrow a.m., Your Honor.
Oh, okay. Can I have that back?
Hello?
I'm going to do this.
Yes,
I'm
who's
gonna
this?
set bonds on it. No, that wasn't the last one.
Oh, hi, how's it going? On that child neglect case, did you call Child Protective Services? Okay,
I'm going to set count 3
sounds good. I
at
just need to confirm that.
$2,500.
Thank you.
I'm going to set count 4
That's it?
at $7,500
All right, thanks, bye.
on Mr. Robinson. Don't bring him back Friday. There you go. $2,500 and $7,500. Okay, may I see Levon Hall, David Lee, Brian Hope, and Rafael Toro? Levon Hall.
North Broward.
Count 3, this is a warrant. I need a possession of a firearm by a convicted felon. So I'm going to go ahead and set your bond at $1,000 on count 3. Thank you. How about David Lee?
Me too.
Sir, count 5, 6, and 7, petty theft, burglary of a conveyance, and petty theft. Court finds probable cause on David Lee. State, what is count 1, 2, 3, and 4?
One moment, Judge.
Allegedly, this defendant in the city of Pompano broke into, I believe, a vehicle.
He's being held no bond on each count for violating pretrial release. Burglary, grand theft, unlawful possession of another's ID.
Right, allegedly broke into a home in Pompano, stealing wallet, credit cards, caught on video surveillance. Okay. Mr. Lee, do you have any money in the bank?
No, sir.
How long
Judge,
have you
Mr.
lived-
Lee, he has a job. He works at Caribbean Cruise Lines. He's been there for 13 years. He's a 30-year resident with strong family ties, including a mother, 2 brothers, 2 children. No money in the bank, as I said, no one to help bond him out.
Does he have any other criminal record?
One moment, Judge. Yes, Judge.
Restroom, please. Trying to find it on pretrial record order. Got it.
2014 felony theft, 2012 possession of firearm by convicted felon.
That's good. Sir, count 5 is 1,000. Count 6 is 10,000. 7 is 1,000 based on your criminal record. Facts of the case. Thank you. Brian Hope. Brian Hope.
I know.
Possession of a weapon.
John
by-
Catrone is Mr. Hope's attorney, Judge.
Your Honor, I actually left a message with Mr. Catrone's office to call me this morning. I was hoping to reach him because, well,
Is it John Catrone?
Yes, he set him for a status. He's got a Dade County hold, so.
Okay, I'm going to set this. Go ahead.
Judge, Mr. Hope is saying he wants to waive Mr. Catrone's presence and go forward.
Well, I don't think. Here's the issue, Your Honor. I guess he posted. A bond was set that he posted, and when they brought him back up from Dade, or there was, I don't know what happened, but now they're being held in no bond. Now, normally I would say, he shouldn't be held again, but the issue is, what he's being held on out of Dade is VOPs on serious charges, and he's continuing to get gain time while he's here now. And that's what I wanted to talk to Mr. Catrone about, and I really think it's, frankly, something his attorney should have.
For 1:30 today, all right? Thank you. 1:30 today?
Straight out.
Thank you.
Okay.
Straight down.
Page
Give me about 10
16.
seconds real quick.
Oh,
I'm gonna
needs
send
to be
this.
sent.
Okay, how about Rafael Toro?
Mr. President, jail, we're looking for pre-trial for him.
Sir, count 1 petty theft, 2 possession of alprazolam, 3 morphine, 4 diazepam, 5 cocaine. Court finds probable cause. Steve, do we have a criminal record on this gentleman?
No, Your Honor.
No criminal record. And tell me about this defendant, Mr. Miller.
Judge, he's been here for about 2 years. He works for Carnival Cruises. He's been there for about 1.5 years. He does have some money in the bank. He will be asking his friends to bond him out. We were hoping the court would consider pretrial release with a barred component.
Wait, I'm sorry. He does have, just not under this name.
Okay, he's also known, his name's Rafael Toro, but he's also been known as Justin Rizzo in the past. Justin Rizzio. Go ahead.
One moment, I just need to check the status of the case. More than that. Your Honor, he has a pending case in front of Judge Destry, out on bond for grand theft, possession of morphine, and battery.
Right.
He also has a prior 2013 possession of marijuana, 2009 theft.
Go ahead, what's the case number? Is that on?
147211 CF10A.
Now, is he out, is that under his alias?
Yes, Justin Rizzo.
Okay.
That's another case.
Okay. All right, sir.
No, it's Rizzo.
Apparently, you're using Justin Rizzo. You have an open case for, was it drugs and what else over there?
Rizzo. Drugs, theft, and battery.
Drugs, theft, and battery. But today, you're Rafael Toro. So, based on your criminal record of prior theft and your noting you're already out, the court's going to, in the facts of this case, set your bond on count 1. That theft is $1,000, and your bonds on count 2, 3, 4, and 5 will be $1,000. Your bond is revoked on 147211 CF10A. You'll be held without bond. Thank you.
Judge, we're requesting a SAP order for Mr.
I'll
Toro.
order that. Thank you.
Thank
Messi
you.
Rigoberto
All right,
or Alana Benitez.
Hello, Judge. 1 second, please.
No.
Outside, sir.
Okay. Do you swear or affirm to translate from English to Spanish, Spanish to English, truthfully and to the best of your ability?
Yes, I do. Estoy Mary, Spanish interpreter.
Okay. Do we have Mr. Orellana Benitez over there?
Tenemos al señor Orlando Benítez.
All Ryan. Good morning, sir.
Señor Orlando Benítez, buenos días.
Sir, on count
Buenos
3
En el cargo número 3, señor,
and 4,
y 4,
you're charged with 2 sex crimes.
se le está acusando con 2 cargos sexuales.
Judge?
Yeah, go ahead.
I'm sorry, is this on Rigoberto?
Yes.
Your Honor, he's
Yes,
actually
Rigoberto.
scheduled for a
Ha sido fijado
Arthur hearing before Judge
para una
Usan this
audiencia
afternoon.
Artur con el juez Susan esta
I'm not
tarde.
going to take any
And
action.
I would ask if you could ask
Entonces
to
no voy a
make,
tomar ninguna
to make
acción.
sure he gets in front of Judge Usan this
Igualmente
afternoon. I believe he's scheduled
I'm not
from
going to
next
take any
week.
action. I'm going to
No voy a
leave
tomar
those.
ninguna acción, voy a dejar que
Usan
el juez
determine
de él se encargue de su caso.
Paul Ryan facility.
Yes, Your Honor.
I've been told this gentleman has a hearing today in downtown. What time do we know?
I think it's 1:30.
1:30, so he may need to get on a bus pretty quickly, all right?
No problem. Who was the judge again?
Siegel,
No, Usan. You
Usan.
want to see it back?
Sorry, Usan,
Usan,
USAN.
okay.
Thank you.
It's,
No problem, Your Honor.
Okay. You want to make an announcement for Spanish?
¿Alguien más para español? ¿Alguien necesita intérprete en español?
Yes.
¿Alguien necesita intérprete en
Yes,
español?
we have one over here.
Who's that?
oh, Your Honor.
Judge, page 26.
Your Honor, I'm sorry. Under Rolano Benitez, I think, Your Honor, for the jail to be able to process it, I think you have to order him held no bond, and if you could put on there no bond for Judge Usan to determine.
Put on no bond for USAN.
Moncada Gonzalez. Decline PD.
What's this gentleman's name? Oh, I
It's
got
the
it.
last case.
Benito Moncada Gonzalez, page
Okay,
26
good
of the
morning,
document.
Mr. Moncada Gonzalez.
Buenos días, señor Boncala González.
Sir, it is very important that you do not make any comment today about why you were arrested.
Señor, es muy importante que usted no haga ningún comentario el día de hoy acerca de por qué usted fue arrestado.
You don't need to say anything.
Usted no tiene que decir nada.
You have the right to remain
Tiene
silent,
el derecho de permanecer en silencio.
but if you give up that right,
Así que si usted renuncia a ese derecho,
whatever you say can and
lo que
will be
usted
used
vaya a
against
decir
you.
puede ser y será utilizado en contra suya.
I may ask you a
Voy
question
a
or two,
hacerle una o dos preguntas,
but other than that, please
pero
don't
aparte de esto,
comment.
por favor, no haga ningún comentario.
You understand?
¿Usted entiende?
Please tell him I say.
¿Entiende, señor?
Sí.
Yes.
Okay, statement. I believe that it's count 1.
Actually,
Are they all?
I'm sorry, Judge. Actually, 2 and 3 are PBLs. 1 and 4 are not.
2 and 3 are first degree PBLs.
Just let me handle this. And
State, are you relying on the affidavit?
Your Honor, and I won't go into any details, Your Honor. I'm relying upon the affidavit. I'm also relying upon the alleged admission that I believe really adds credence and corroborates the victim's allegations, Your Honor.
Right, okay. Now, the court's going to find proof evident presumption grade
El
as to
tribunal va a
count 2 and
encontrar
3.
pruebas, presunción en los cargos 2 y 3.
The court does note the defendant
El
allegedly
tribunal
made
sabe que el acusado presuntamente ha hecho una confesión, supuestamente.
and state,
Moncada Gonzalez.
let me ask
Fiscalía,
you,
déjame hacer esta
does he have a
pregunta.
criminal record?
We're checking
¿Tiene
that
un
right now,
antecedente
Judge.
penal?
Mr. Moncada
Estamos verificando
Gonzalez, how
esto,
long have
señor.
you lived in South Florida?
Moncada González, ¿cuánto tiempo ha vivido usted en el sur de la Florida? ¿Cuánto tiempo ha vivido en el sur de la Florida?
No le entiendo bien la pregunta.
I don't understand very well the question, Your Honor.
How long have you lived in South Florida?
¿Cuánto tiempo ha vivido usted en el sur de la Florida?
11 años.
11 years.
Do you have any money in the bank?
¿Tiene usted dinero en el banco?
¿Perdón?
¿Tiene dinero en el banco?
No.
No.
Do you have family in South
¿Tiene
Florida?
familia en el sur de la Florida?
Sí.
Yes.
Okay, do you own your own home?
¿Es usted propietario de su casa?
No.
No.
Okay, go ahead.
Your Honor, there's no criminal record, but
No hay
there's
ningún
also
antecedente penal,
nothing in the
pero
database.
tampoco no hay nada.
So the court's going to set your bond on
El,
count 1,
El señor,
count 4,
la sala
$25,000 per count,
le va a imponer una fianza. How much, judges? I'm sorry.
$25,000.
$25,000 por cargo.
Count 2 and 3, you're going to be held without
Cargos
bond.
2 y 3, usted va a permanecer detenido sin derecho a fianza.
The court will order no contact
El contacto no, va a ordenar que usted no tenga
A
contacto
female
con una
who
mujer
has the initials of TG.
cuyas iniciales son T,
Thank you, sir.
P. Gracias, señor.
Good luck to you, sir. There you go. Down the middle, out the door.
Okay, when I call it, I think that's it, ma'am. Thank you.
That's it. Okay, thank you.
Come on. Okay, Rick, thank you. Richard Nelson, Anthony Perez, Joshua Schuman, and Brady Williams.
Judge, Mr. Nelson is present at the main. We'll be seeking pretrial release for him.
I understand. So you've been charged with cocaine and paraphernalia. Court finds probable cause. State, does this defendant have a criminal record?
Your Honor, he has theft last year, possession of cocaine 2012.
Mr. Miller?
Judge,
Go ahead.
no, I'm sorry. It's been here for a month. He came down here from New York to obtain VA benefits from what he says is the best VA in the nation.
I'm not gonna, I reserve comment on that last, but go ahead.
He said he did his due diligence, and this is the best place to be. He's going to be staying with friends. He's a 12-year veteran of the United States Army, discharged as an E6 with an honorable discharge. We'll be asking for pretrial release with marked conditions.
Which branch of the service was he in?
United States Army, sir.
Now, let me ask you, do you have somewhere to go? Do you have an address you will be staying?
Yes, sir.
Just to let you know, if you want to consider a pretrial, it looks like the cocaine goes as far back as when he was in the military.
Right. Okay. So, what's your address going to be?
13. Got it down. This one's 13, pins 1 and 1. Done. Right there.
1 Northwest 33rd Avenue, Lauderhill, Florida. 33312. 1 Northwest 33rd Avenue, Lauderhill, Florida, 33312.
Give me the zip code one more time.
33312, Judge.
Okay. I'm going to go ahead and release you on your own recognizance, sir. You have to report your pretrial release today by 4 o'clock. If you don't make it today by 4, you have to be there tomorrow between 8 and noon. All right? Today by 4, tomorrow between 8 and noon. Thank you.
Yes, sir. Thank you, sir.
ROR, this gentleman to pretrial. Yes, thank you. I have his address. Ma'am, I put an address on here. Okay. Thank you.
Yeah.
How about Anthony Perez?
Judge, I just see a warrant, but I don't have any circumstances. I'm not making a probable cause argument. Judge Uson already found probable cause, but
Aggravated battery, count 1, fleeing, eluding, count 2. License suspended, count 3. Count 4, 5, and 6 are warrants.
I can provide.
Your arrest, count 4, 500. Count 6, 500. Count 5, 500. Count 6 ROR. And then
If you want to put on a brief recall, I can pull the piece.
we'll be right back. Have a seat, sir.
Well, I'm saying if you want to. Oh, okay, never mind.
How about Joshua Schuman? Sir, count 1's 1,000, 2 and 3 are violations of pretrial. They're both no bond. Thank you. How about Brady Williams? Brady Williams?
I also don't have paperwork.
Count 1, aggravated fleeing and eluding, fleeing with injury or damage, I'm sorry. Count 2, DUI, property damage. Count 3, leaving the scene of a crash involving damage. Let me look here. Okay, so court finds probable cause. Do we have any criminal record on Mr. Williams?
One moment, Your Honor. Yes. His record includes possession of cocaine, 03, strong arm robbery, dealing in stolen property, 03, 10-year state prison, Delivery of cocaine, possession of cocaine, 91, 3 years. Tampering with evidence, 89, here in a day. Theft, 88. Cocaine, another theft in the mid-80s, Your Honor.
Got it, okay. Now, Mr. Miller, anything you'd like to say today?
Sure, Judge. 57-year resident of South Florida with strong family ties, including his mother, his sister, his fiance, and 2 children. He's currently receiving disability. He has some money in the bank. He will, however, be asking his fiance to post bond for him.
I understand. Sir, I'm going to set count 1 at 1,000. I'm going to set count 2 at 1,000, 3 at 100, and noting your criminal record. Thank you, sir.
That much to a bond.
How about Todd Warren, Ankeel Franklin, Alvin Goodwin, and Burrell Sands? Todd Warren, burglary of a dwelling, possession of burglary tools, illegal use of credit cards, and burglary of a dwelling. Quick finds probable cause. State, do we have a criminal record on this defendant?
2000, uttering a forged instrument and grand theft. He pled out the case as a habitual offender. 2013, uttering a forged instrument with a VOP.
Okay, let me just... VOP, okay.
2011, burglary conveyance and possession of burglary tools. VOP, a year and a day state prison as a habitual offender. 2010, Berg structure, felony theft, a year and a day, habitual offender.
Okay, Berg, structure, and felony petty theft?
Yes, Judge. 2010, Berg structure, VOP, year and a day. Resisting without violence and theft, 08. Resisting without violence and theft, 08. Possession of cocaine, 08. Lording or prowling, 08. Possession of cocaine, 06.
Got it. Okay, Mr. Miller, go ahead.
Judge, Mr. Warren is a lifetime, he's been living in Florida for about 20 years. Most of his family lives in Fort Myers.
Okay.
He has no money in the bank or ability to bond himself, and he's not sure who's going to help bond him out.
I understand, sir. It looks like you burglarized 2 homes, one in February 2nd, the other one January 17th, removing bicycles valued at $13,000, a generator, a lawnmower. Another one you allegedly burglarized, allegedly removed jealousy windows and ran away after the alarm had sounded, but court also notes, all right, so, all right, sir, the court, based on your lengthy criminal record, you've been declared a habitual offender in the past, multiple burglaries in the past, 1, 2, 3, grand thefts, multiple thefts, loitering or prowling. Sir, the court believes you represent a danger to the community based on your criminal record, the facts of the case. Berg dwelling on count 1's $25,000, 2 $1,000, 3 $100. Berg dwelling on count 4, that's $25,000. You can bond out. Your bond's $51,500. Thank you, sir.
I have the paperwork on Perez whenever you're ready, Judge.
Sure. How about Ankeel Franklin? Okay, Mr. Franklin, aggravated assault with a deadly weapon.
Franklin. Helene Raisman is his attorney.
Okay. Helene Raisman.
Now you been talking all day. Chill out. Yeah, you.
Okay. So I'm going to reset you for 1:30 today, all right? We'll bring you back at 1:30. I'm going to send this right to your attorney right now. Hold on. You know what? I thought I had Helene Raceman's telephone number. Hold on. I'll take care of it.
That one needs to go back. When court
You handed me something.
That's for Perez.
Okay, Mr. Perez, sir, aggravated battery on a police officer, fleeing and looting, license suspended. Give me a quick moment, I need to read something, hold on. All right, sir, you're here, aggravated battery on a police officer, fleeing and eluding the police, license suspended, quick finds, probable cause state. Do you have a criminal record on?
One moment, Your Honor.
Misdemeanors are 4, 5, and 6.
Okay, he's got another pending, one moment, I just need to see when this happened.
Go ahead, state.
Your Honor, after this occurred,
Right.
he was arrested on a not in custody and posted bond December of last year on another aggravated fleeing and eluding, so that's pending.
Really? He's got it?
Yes.
Okay.
06, was convicted of 4 counts of strong arm robbery, 1 count of grand theft auto, sentenced to, I don't know exactly how many years, but 101 months state prison.
Okay, so, and 1 count of strong,
No, 4 counts.
4 counts of strong arm robbery and 1 count of what?
Grand theft auto.
Got it.
05 attempted Berg structure with a VOP, 101 months.
Okay,
Berg,
attempted Berg structure.
Berg dwelling, 04, VOP, 101 months.
So went to prison on all 3, right?
Yes, they were all concurrent.
Okay. 100 and how many months?
101.
101 months. Got it. Okay, Mr. Miller, anything you'd like to say today?
Judge, when was this count 1 and 2 alleged to have occurred?
October of last year.
October 29th.
Okay, well, since then, Mr. Perez is advising me that he's in culinary school. He was actually picked up at school during an exam. I didn't get much beyond that. I'm going to ask the court to go ahead and appoint the public defender's office to represent him. And then ask the court to arrange for a mental health screening for him.
Can we find out, does he qualify for the public defender? Sir, do you have any money in the bank?
No, not at all, sir.
Do you own land or property here in South Florida?
No, not at all, sir.
How long have you lived in South Florida?
Almost 30 years.
Okay, do you have family down here?
I do, but then I don't at the moment. It's like I was at a Pablo Beginner's halfway house, and I've been
Do you have
considered that
family
as
here
my
in South
family.
Florida?
Yes, I do.
Who do you have?
Well, I have my grandmother, my daughters, my dad, my uncles, my cousins, but
Okay.
nothing involving me.
All right, sir. So today, the court believes you represent a danger to the community. While this case, before you got arrested on the October 2015 case, after that, you've subsequently been arrested for, was it aggravated fleeing and looting?
Yeah, he was arrested for it, and that's pending.
Arrested for it. That case is pending. That doesn't violate this case. Sir, you've already gone to prison for strong arm robbery, 4 counts, grand theft auto, attempted burglary, and a burglary. You're 30 years old. And in this case, you allegedly try to run over a police officer and you're able to clip another police officer. Court is concerned for the safety of the community. And also noting you don't show up in court as evidenced by count 4 and 5 being warrants for your arrest. So $25,000 on 1, $10,000 on 2, $5,000 on 3. Count 4 and 5 are $500 per count. Based on your criminal record, the facts of the case. Thank you.
Judge, you went kind of fast on there. I didn't get a chance to write those down. Can you repeat those bond amounts?
25, 10, and 5.
Where was the 5,000, Judge?
5 is on license suspended.
500.
All right. Thank you.
Well, where's the 10,000, Judge?
Count 2. 25,000, 10,000, 5,000. Count 4, 5,
Thank you,
and 6
Judge.
are.
And you're going to appoint us to represent him?
Yes, sir.
Thank you.
He is appointed. Okay. Alvin Goodwin. Sir, license suspended. Count 1, violating probation on count 4, which is license suspended. Count 1, 750. Count 4, no bond. Thank you. Beryl Sands. Beryl Sands, please. Beryl Sands, step forward. Beryl Sands, burglary of a structure, cannabis, court finds probable cause. State, do we have a criminal record on this defendant?
Yes, Your Honor.
Sands, are you currently employed?
Yes. Judge, we're going to be seeking pretrial release for Mr. Sands. He's a lifetime resident with strong family ties. He works at Burger King, and additionally, he goes to Broward College, where he's studying accounting and electrical engineering. He's actually in his 2nd year there, Judge. No money in the bank. He is a registered voter here in Broward County. Not sure who's going to help bond him out. He will be asking his family to do that. We'll be asking the court to consider pretrial release with a marked component.
Resisting without violence, 2011. Again in 2012. Theft, 07. That's all, Judge.
So I'm going to release you on your own recognizance. Thank you. How about Jimmy Worrells? Sir, grand theft count, where's Jimmy Worrells?
North.
Sir, count 1 is grand theft, 1,000, 2 parole violation, no bond. Thank you. Terrence Jean Baptiste, Keith Hurd, Guyerson Maddie, James Childs.
You got this. Judge, I need to recall Mr. Goodwin when you have a moment.
Mr. who?
Mr. Goodwin, he's the one right before Sands.
Okay, I've got Goodwin here. What do you need?
Oh, come on, Goodwin. Judge, everything moved kind of quickly, but he's telling me he's not on probation.
Who that is?
Alvin Goodwin.
Yes, he is. Judge Lerner Wren signed the warrant the day before he was set to terminate.
Oh, thank you, Judge. Thanks for clearing that up, Mr. Linder.
Thank you. How about Terrence G. Baptiste? Sir, possession of PVP and cannabis. Court finds probable cause. Do we have a criminal record on Jean Baptiste?
2011 burglary of a dwelling, 26 and a half months state prison. 2011 theft. End of record.
Got it. Mr. Miller, anything you'd like to say?
10-year resident, Judge. He has no money in the bank to bond out, and but he's going to try to bond out
So I'm
anyway.
going to let you bond out based on your criminal record and tax case. You bond 1,000. Thank you. Keith Hurt.
Good luck.
Good morning. Good afternoon, Your Honor.
Good afternoon. Possession of harmful, new legend harmful drug. Quick find probable cause. You're wanted
Good luck to you, man.
out of
Hey,
Martin
get some
County.
help,
Count 1, ROR. Count 2, you're being held for Martin County. Thank you, sir. How about Garrison Matty? Move out of the way, sir. Move out of the way. Thank you. Garrison Matty, possession of cannabis, license suspended habitual. Hold on, Matty. Let me take a look here. You have a Class C license. I'm looking here. Habitual traffic offender. Failed to pay traffic. Habitual traffic. Failed to pay traffic tickets. Failed to appear in court. Failed to appear in court. No. Failed to pay traffic tickets. These are all out of West Palm. Failed to pay. Failed to appear. Multiple pages here. So I'm going to let you bond out. Count 2750. Thank you. How about James Childs?
What was count 1, Judge?
Possession of cannabis. That's ROR.
No,
Thank
the
you.
ROR. Thank
Count
you, Judge.
2, sir. Child's grand theft, dealing in stolen property. Court finds probable cause. Allegedly removed a custom kayak and a Cannondale bicycle from an address in Fort Lauderdale. And allegedly sold the kayak for $175. State, do we have a criminal record on Mr. James Childs?
Your Honor, looks like he has a prior theft out of Georgia.
What year was that?
Looks like it was in late 80s. And 03 out of Broward, disorderly conduct. That was pled down from a domestic violence case. End of record, Judge.
Okay. Mr. Childs, are you currently employed?
Judge, Mr. Childs is a caretaker for a 70-year-old gentleman who allows him to stay there with him in exchange for him helping. He's been here for 17 years. Does not currently have money in the bank. He is, however, a registered voter. He's going to be asking the person who he's helping to bond him out.
Okay. So I'm going to let you bond out today. Count 1's $1,000, 2 $3,500. Based on your prior Georgia petty theft, the facts of the case, the amount you valued at $4,000. That's how much the bicycle and the kayak were worth. Thank you. How about Richard Chinloy and Dwayne Schneider? Chinloy, sir, possession. Let me look here. Sir, count 1, possession with intent to sell, deliver heroin, $2,502. Possession of cocaine, $1,000. 3, oxycodone, $1,000. 4, PVP, $1,000. 5, resisting arrest, $100. 6, tampering with evidence, $1,000. 7, municipal ordinance, ROR. KPS on count 8, $100. Then count 9 through 12 are warrants on felonies. They're all no bond. Thank you, sir.
Judge, we need a SAP order for Mr. Chinloy, please.
Understand. I'll order that. Dwayne Schneider.
Okay.
Schneider,
Yeah.
count 3, you have a warrant on a felony. Need to set a bond on that, I believe, right, State?
Who's this, Your Honor?
This is Mr. Schneider, Dwayne Schneider.
Yes, this was we had him last week, Your Honor, on a motion to release where we informed you we combined the robbery with the aggravated battery. I think he's got a $15,000 bond on one of the charges. One moment.
We're going to take care of the municipal ordinance cases at 1:30, and those are going to be only one case, Francis Brill, 1:30.
Yeah, he's got a $15,000 bond on the strong arm robbery on this case. One moment, I can. I think it had to do with injuries. The victim was punched in the face multiple times. Had to be taken to the hospital. I think the aggravated battery had to do with the bodily harm.
Okay, so who's going to set your bond on count 3, sir, at $1,500, all right? Thank you. Okay, so this. I think that's a wrap. Am I correct?
That clears me at the main, Judge. May I be excused?
What else do we have? Yes, sir.
Thank you.
What else do you think we have? Okay, we're out from 2:35. Thank you.